My lord, this IA is for condonation of delay of 114 days, my lord, in filing a writ appeal.
কিন্তু যে আয়ের মানে একটু কিন্তু নতুন ধরনের সিঙ্গেল মধ্যে গ্রিভান্স একটু হচ্ছে itu confirmation ইয়াতে আপনার নোটিশ দিয়াই নেই নোটিশ
Lordship, I am appearing on behalf of DSTI M. Kato for all the respondents.
Notice has not yet been issued. In this matter,
No, my
notice not issued. Let notice go at this instance. The Kato is not available,
No, Lordship, he is out of station.
out of station.
Yes, Lordship.
Heard Mr. N. Pada, learned counsel for the applicant, and also heard Miss
Yasmin Gao.
learned counsel appearing on behalf of Mr. M. Kato. The learned counsel appearing on behalf of M. Kato submits that Mr. M. Kato is out of station. So we should adjourn the matter.
Yes, Lordship.
And say price for listening the matter after 1 week or 2 weeks.
Lordship, 2 weeks.
After 2 weeks. After 2 weeks. However, it appears that notice is yet to be issued in this application. Accordingly, it is provided that notice be issued to the respondent stroke opposite party. Opposite party. However, no formal notice is required to be issued since all the respondents are represented by Mr. Kato, learned counsel for the respondents. Learned Mr. Kato, learned DUY as the place the matter after 2 weeks.
Obliged, Lordship.
In the meantime, the response on the opposite party may file their objection, if any.
May I please, Your Lordship?
Hmm.
In this matter, appellant expired. So matter may be closed. Appellant is no more now.
Okay,
Yes.
so the legal representative will not pursue the matter.
But they are not informing me that they inform me that the
Appellant
appellant
summer denied.
expired. Yes.
Okay. Heard Mr. Deka, learned counsel for the petitioner, and Mr. Kato, Mr. Tarak for respondent authorities. Respondent
1 to 5.
1 to 5.
Yes.
Mr. Deca, learned counsel for the petitioner submits that the legal representative of the petitioner informed him that the petitioner suffered demise.
Yes,
And as such, Mr. Deca submits that the matter may be closed. Whereas accordingly, taking note of the submission of Mr. Deca, learned counsel for the petitioner, there's a writ petition, that this is writ petition stands closed.
May it please Lordship.
That's the affidavit.
Lordship, as per the last order, that is 05/05/2025, we have taken a step through Dusty to respondent number 1 and 2. And we have filed a report, service report on second, Your Lordship, second,
Where is your affidavit?
we have already filed, Your Lordship.
You have filed.
Yes, we have filed, Your Lordship.
When?
On second June 2025, Lordship.
There is office note that no affidavit has been filed.
If you electronically, yes.
Lordship, we have been engaged for, in this matter, we have been engaged for respondent number 1 and 2. Copies have been received by the respondents 1 and 2. We will be filing wakalatnama, Lordship.
Okay. And for rest of the respondent, Mr. Rotan for
My lord, I'll-
number
I'll appear for respondent 4, 6, 7, and 8.
4, 6, 7, and 8.
Yes.
And Madam, you
I'm appearing on behalf of DSGI for respondent number 3 and 5.
respondent number 3 and 5.
3, 2, 5.
3 to 5.
No, 3 and 5, sorry.
3 and 5. And you, Mr.
For respondent number 1 and 2.
1 and 2. Okay. Heard, Mr.
Yes, Lordship.
Learned counsel for the
G
petitioner.
Ovin.
And Mr. N. Roton, learned additional advocate general for the respondent number 4, 6, 7, and 8. And Mr.
Di Tali.
learned counsel for the respondent number 3 and 5. And Madam,
Uh,
for respondent number 1 and 2.
Lordship, I am for respondent number 1 and 2.
You are 1 and 2.
Yes.
And you for
Three,
Lordship,
four,
I'm for
3 and 5.
respondent number 3 and 5.
3 and 5. Okay. 3 and 5. So you want to file affidavit?
Lordship, yeah, matter may fix on 20 will, conducting counsel PD Nair, he will appear on 20.
Acha. Wakalatnama file. No wakalatnama has been filed.
No, Lordship.
The learned counsel appearing for respondent number 1 and 2 submits that the conducting counsel is out of station.
He's, due to some unavoidable circumstances, he's not present today one.
The conducting counsel is not present today in the court. And as such, a best for listening the matter on
20 of this month.
28th of June. 28th of June. And he will be filing his wakalatnama within 1 week from today.
Yes, Lordship.
Within 1 week from. Accordingly, it is provided that this is shall list the matter on 20th June 2025. And in the meantime, the respondents may file their affidavit in opposition.
Obliged, obliged, Lordship.
May I plead your lordship? Matters relates to PL relates to illegal operation of stone crushers. Not as per the guidelines.
2, 5. Let's keep it. That's going to
Well, in this
But
PIL,
the private respondents are, both the private respondents, Mr. Pertin and Mr. Jamo, HK Jamo, they are not present today.
They are absent today.
Yes, they informed me that they will be seeking time, but none has appeared.
I'm appearing on behalf of Tony Patin for private respondent number 10, Your Lordship.
Party.
Private respondent 10, Your Lordship.
10.
He's due to some personal difficulties, Your Honor, he is out of station, so this matter may be adjourned for today, Your Lordship.
Number 10 is located 5 km from Nehru Reserve. 500 meters. Okay. No. So, have you seen the affidavit?
yes, I have seen the affidavit. So it also covered by, it also comes under the reserve forest area. Your
How?
Lordship. It's as per the government affidavit, Your Lordship, I have seen that. Paragraph 3. Paragraph 3 and Annex 2.
If I may be
So-
given just a minute,
Yes,
Malak, to
yes.
explain the whole issue out here. Well, the issue out here is whether for setting up the stone crusher unit, the guidelines were followed or not. Here, it is not in dispute that both the private respondents, they have established their crusher unit in their private land. It is not in the reserve forest. The guidelines, however, provides many conditions, criteria. One of the criteria is that it should be 5 kilometers away from the reserve forest. Now, the issue here is, in our affidavit, we have said that, yes, these are guidelines, but some crusher units, they are not, they are within 5 kilometers range, but they are not in the reserve forest. Some relaxations have been given. Because in this terrains, there are many means where the crusher unit, 5 kilometers from the reserve forest cannot be done. Now, NGT for respondent against respondent number 7, I believe. Nine. In NGT, another petition was filed. There, on the basis of that guidelines, NGT has ruled that it is beyond the guidelines, 5 kilometers, within the 5 kilometers range. So that his stone crusher unit is illegal. Now, therefore, whether the query came, whether the second respondent, private respondent, his query also is within that 5 kilometers range. Now, that is the issue here. Here, as per our affidavit, yes, it is all, around 2.4 kilometers from the aerial distance is in paragraph 3, approximate 2.4 kilometers from the reserve forest. Now, the issue here, my lord, what will have to be, I will not step in the shoes of the private respondents, but whether the establishment of the crusher units may be within 5 kilometers from the reserve forest, but not within inside the reserve forest. The main issue will be whether there is pollution or not. Therefore, the Pollution Control Board, which is a party out here, needed to have been, they need to file an affidavit after verification whether they are, these stone crusher units are causing pollution or not. That was the, but in the meantime, already the NGT has already taken a view. And one more thing will be that whether the NGT's order will be binding upon this honorable court. That is also. Now, therefore, whether the private respondent 9, they have gone on appeal against that NGT order, these are to be.
Let us adjourn the matter.
Yes, ma'am.
Heard Mr. Esmail, learned counsel for the petitioner. You are in both the
In fact,
petitions?
if we
Yes,
strictly
both
follow
are
the
petitions.
stone crusher guidelines, the if we strictly follow that criteria of 5 kilometers away from the reserve forest, many stone crushers.
He wants to endure or he wants to argue, then I think petitioner has
So
to.
now you are appearing in only in item PIL, not in the writ petition.
No, not in the petition.
Okay, only in the PI. In PI. Heard Mr. Mao, learned counsel for the petitioner. And also heard Mr. M. Roto, learned that is lazy. For the respondent number 1, 2, 4,
4 to 8.
1, 2, and 4 to 8.
4 to 8.
And Madam appearing for
Respondent number 10, Your Lordship,
respondent number 10
on behalf of Tea Party.
on behalf of
Tea Party.
Tea Party. Yes, Tea Party. For appearing on behalf of Mr. Tea Party, learning counsel for the respondent number 10. Who is for 9? Yeah,
9 is
Mr. HK Jammu.
HK Jammu.
HK Jammu was appearing.
none appears for the respondent number 9. No, yes, respondent number 9. Miss so learned counsel appearing on behalf of Mr. Tea Party. Learned conducting counsel for the respondent number 9 at 10 submits that party is out of station. And also say request that to adjourn the matter for 2 weeks or 1 week or 2 weeks.
After 1 week, Your Lordship.
1 week. 1 week. There is a hello. list the matter after 1 week. Then in second read petition,
Second writ petition is because of the pendency of this PI. It is the writ petition by the respondent number 9.
Mr. Mao, you are not in this petition.
No, I'm not in this petition, Your Lordship. I'm not in this. Obliged.
None appears for the petitioner on call. How about Mr. Yapa, Learned Standing Counsel for respondent number? Here you are respondent number.
My lord. For the state respondents, my lord.
2, 3, no, 1, 2, 4, 5, 6.
All the
7,
respondents,
8.
all the respondents.
No, sir.
Mr. M. Gautam, learned additional levy for all the respondents.
No,
present.
not for all the rest.
So additional deputy commissioner, Pasigat, assistant mineral development officer.
Mr. Nathan, you will be, it's all state respondents, state geologist, deputy commissioner, assistant mineral development officer,
Okay,
additional deputy commissioner.
yes, yes. Fine, no.
List the matter after 1 week, along with along with PL number 1780.
Yeah, Balaji.
May I please lordship? Lordship, this is an appeal under section 374, clause 2 read with section 482 of Code of Criminal Procedure, 19th century. Challenging the conviction order dated, judgment order dated 4th of the. according to-
All the parties are present.
Honor,
You are home? 15, okay.
so, one more person, lordship, that is informant, respondent number 2 is
Respondent number 2 is.
is the informant. Victim is
He is
the.
appearing. Mr. Bhatta says he is appearing.
The lordship in this case, in the judgment order is in a paper book page number, lordship, 41. Page number 41, paper book.
Oh, who is for the respondent number 2 then?
Your Lordship, since the informant has come, Your Lordship, because the FIR was filed
No,
by.
he is for victim only.
Yes. No, he is for the
Informant is the.
brother of the victim.
Then you can represent both of them.
Actually, lordship, this victim and the informant, they have disputed. So because of that leading to FIR against me. So this is the case of.
No. First,
Yes.
Mr. Bhatta says you are appearing for 2 and 3.
I'm preparing for the 15, but
Three.
no, 100 hours we try and we have important.
2.
That is a important problem.
So would it be proper to hear the matter in absence of any representative of this respondent number 2?
Lordship, victim is there, then lordship, it can be because in cases relating to the husband and wife issue, already given birth to the child, only the conviction is basis of the birth certificate. Informant was the elder brother of the victim. So victim, elder brother was disappointed with our love relationship, leading to FIR, and the trial court has convicted me for 20 years under section 6 on the basis of birth certificate. That is also victim was totally not aware about the birth certificate. In the question, lordship, directly come to the lordship trial court, that's the question of the victim, lordship. Page 29, lordship. Page, paper book page number 29 is the victim evidence that it was recorded in the trial stage. May I read out, lordship? My name is Srimati Rankivara. My husband name is Sri Takabara. I am the Takabara. In below an oath, I know the accused is my husband now. Accused Takabara from my same clan, and I know that he is already a married man But even after knowing all these things, I have fallen in love with him. When I was staying at Jantia village at the residence of my elder brother and sister, Gedi Bara Rimo, I called Takabara to take me from the residence of my elder sister, and I told that I want to go with him. Accordingly, Takabara came and I along with him went to Bandurdua. We stayed at Bandurdua for about 1 or 2 days. Thereafter, we went to Pasigat and stayed there together for 2 to 3 days. From Pasigat, we went to Inkyong, and thereafter we went to Tuting. We stayed together at Tuting for about 3 or 4 months. Then one day, Tuting police came. Takabara was arrested by police and taken into custody. Then I called my sister-in-law over phone and inquired as to who has made complaint. I was told that no one have made any complaint. Then my elder brother, namely Bargi Bara and sister-in-law with Sapa police came to Inkyong for taking me back. Tuting police brought me up to Inkyong, and from Inkyong I'm taken back to Sapa. Takabra was also taken into Sapa and he was detained in Sapa PS. I was allowed to stay there.
Your good name? T. Kapoor. Learned counsel for the appellate. And Mr. Ms. Zini for respondent number 1, state respondent number 1. Then Mr. Bhattacharya for respondent number 3. It appears that though notice was issued to the respondent number 2, the informant, there is no indication about service of notice upon him. Accordingly, it is provided that Ms. Zeni learned additional PP shall obtain necessary instruction from the jurisdiction officer in jurisdictional PS regarding service of notice upon respondent number 2. Respondent number 2. Further, it appears that this appeal is being preferred by one Punya Tai, who is not the convicted person. The learned counsel for the appellant submits that he may be granted time to obtain instruction in this regard. Accordingly, it is provided that this is the matter tomorrow.
Iya, pokok pala. Isinya ya udah. Nah, Tino kan Tino.
Tapi ini
Ready করেছ? कुछ बोला नहीं है।
Number 13 is a part matter. The additional solicitor generally will appear. This matter may be picked up at 2 p.m.
Today.
Today.
PM. Okay.
Only.
My lord, I would like to mention for item number 1. It
Yes.
was fixed at 2 p.m. My lord, there is some typographical error and I want to annex some more documents. So I may be allowed to withdraw this petition with a liberty to file a fresh petition.
Okay. Miss, your good name, please.
K. Bhagra.
Learned counsel for the petitioner submits that. She has an instruction to withdraw this petition. And she may be granted liberty to approach this court again by filing appropriate petition. Whereas accordingly allowed, there's a civil criminal revision petition disposal or withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Obliged.
Yes.
Lordship, I beg to mention an unlisted matter.
When?
There's an urgency. So,
When?
yes, Lordship,
When do you want?
yes,
Today or tomorrow?
tomorrow.
Tomorrow?
Yes. Obliged.
The last occasion, your lordship, in this matter.
Yes, yes. Mr. Pisa?
Yes, madam. Well, we have arrived to a decision, my lord. It has to be culminated in order, my lord. I have submitted, my lord. This is our office note, my lord. About serial number 7. It relates to the case of the petitioner, Chetam block. Now, my lord, may please turn to second page, my lord. Next page. After the table, my lord. After scrutiny, my lord. After scrutiny, just below the table, my lord. After scrutiny, NIT documents are following documents. The following funds have been found to be responsive, so and so on. Serial number 7, my lord. MSRR Enterprise for Chetam block.
Hmm.
Now, my lord, only the order has to be passed, but we have already decided.
So there is no question of my lord, lapse of that bid documents, my lord.
So the petitioner's bid is found to be responsive
Not, my lord, the other bidder, my lord. Not the petitioner, my lord.
or not the petitioner.
Not the petitioner.
This was supposed to be uploaded in the website, Lordship, but the
Is it uploaded in the website, Mr.?
Well, this is office note, my lord. This, now
Office
it
note.
has to be culminated in the order, my lord. This is the decision that we have arrived, my lord. So, my lord, we have taken the decision, but it has to be formulated in the order, my lord. So there is no question of expiry of bid validity, my lord. We have come to a conclusion, my lord.
So the petitioner firm is
LY, my lord.
LY
Yes.
Enterprise.
Yes, ma'am.
So his bid is found to be responsive.
Well, what is their decision, my lord? That is to be seen, my lord.
After scrutiny, the NIT document of the following firm have found to be responsive.
Yes,
firm,
ma'am.
as
Yes,
below.
yes, ma'am.
Number one is MS LY Enterprise,
Dapurijo block.
the Parisu block.
Yes, ma'am. Two KK Enterprise for Dumpurijo block. Rizala Enterprise for Nacho block. Solo Enterprise for Giva block. Messrs. MB Enterprise for Barrijo block. Tuxton Enterprise for Sium block. Now it comes for the petitioners. Messrs. RRR Enterprise for Chetam block.
So as per this office note, it is approved.
Yes, my lord. Now the formal order has to be only issued, my lord. So my lord may dispose of this writ petition by directing the authorities as and when the order will be, my lord, issued. The petitioner may be communicated with the order, my lord. That much, my lord. With this observation, this writ petition.
since the department has come to a conclusion, Lordship, we have to file another writ petition, it seems, Lordship.
Pardon?
We have to file another writ petition.
Why?
Challenging this order because as we have allies in the writ petition, Lordship, there was some political influence by the department to issue the.
You have been found responsive.
No, my lord. RR,
No, sir.
some other bidders.
Respondent number two, Lordship. L2 is the some other bidders, Lordship. That is the. That is
L2 has been found responsible.
L2.
L2, Lordship. That is what we have been allies in the
Where
Table
it has
seven,
been-
my lord.
table 7, Lordship.
Serial number 7, table, my lord. Serial number 7, CD block Chetam. First page, my lord.
That is what we have
Serial number
allies in the
7, my
writ
lord.
petition, Lordship.
CD block Chetam, package number 8.
Okay. So you have to challenge this.
Yes, Lordship. That is what we have allies in the writ petition, Lordship.
Read petition, my lord. Only the prayer was for direction to, my lord, complete the tender process, my lord.
In that even, Lordship, I may be allowed to withdraw the writ petition.
That's all right, but what is this? After the table, this note, after scrutiny of the NIT?
Yes, my lord. So, my lord, this RR Enterprise, my lord, has been found responsive, my lord. After scrutiny, the second page, my lord, below the table, after scrutiny, the NIT documents, the following firms have been found to be responsive firms as below.
Hmm.
So they have this down below this serial number 1 to 8, my lord, they have been found responsive, my lord. Not the table which has been given in the first page, my lord.
Pardon?
Not the table in the first page, my lord. It is in the my lord, this serial number 128, which has been mentioned in page number 2, my lord,
Yes.
they have been found responsive, my lord.
After the detailed scrutiny of the financial beat, Lordship, I became an L1. And the department which we have, they have decided to award the work to the L2, Lordship.
So you have submitted your tender for the Setam block,
Lordship.
but you have been selected here for Daporizo block.
Yes, my lord. LY Enterprise for Daporizo block, yes.
No, Lordship.
For other block, my lord.
Other block, Lordship. Since I have been in this red petition, I am challenging for the Chetam block, Lordship.
Only.
Here, my lord, there are 8 blocks, my lord.
Okay.
He has been given work for
So,
the, my lord, Daporizo block.
His bid document is found to be responsive in respect of this
Daporizo block, yes, my lord. Not for Chetam block.
Okay. This repetition pertains to Setam block.
Chetam block, Lordship.
Heard, Mr. T. Goram, learned counsel for the petitioner, and Mr. B. Lisa, learned standing counsel for the respondent authorities.
All the response.
Mr. Pisa, person to order of this court dated 2nd of June 2025. Uh, 30th/5/2025, not second. Has produced one office note. Office note of respondent number of the respondent authorities dated 29/5/2025. And submits that in respect of the second block, one MS RRR Enterprise is found to be responsive, not the petitioner's part. At this instance, Mr. Goram submits that he may be permitted to withdraw this petition and to challenge the aforesaid finding of the respondent authorities. That are taking note of the submission of Mr. Goram, learned counsel for the petitioner, and also considering the facts and circumstances on the record. This court is inclined to allow him to withdraw this petition. Accordingly, this petition stands disposed of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing a petition.
My lord, obliged.
The document produced before the court today shall be part of the record.
Deeply obliged.
Obliged.
May I please, Lordship? Lordship, this is a classic case of illegal appointment, Lordship. The private respondent number 5, 6, and 7 were directly appointed as divisional accountant officer. And the private respondent number 8, 9, 10, 11, 12, and 13 were appointed as divisional accountant under the Department of Hydropower Development Department also. Lordship, through RTI application, the petitioners has filed RTI application before the concerned authority, seeking for the documents of their appointment and the sanction status of the post. Where it is through RTI application also, it is clearly furnished that they have been appointed for initial period of 6 months, Lordship. But thereafter, their service has been extended from time to time since last 10 years, Lordship. And sanction status, the Lordship, that has been provided at page number 53, that their appointment has been made against the sanction post, Lordship, page 53. Type copy, Lordship, at page number 55. And serial number 31. The 56, serial number 31, DAO, Divisional Accountant Officer, and DA, Divisional Accountant. 9 first have been sanctioned in the year 2014, but still they are on contract, means on illegal, on the basis of illegal appointment without any interview. So, Lordship, this is the notice may be issued.
Yes, Mr. Topping.
This is said notice may be issued.
Notice.
This is not.
Heard Mr. K. Lolan, learned counsel for the petitioner, and Mr. S. Toppin, learned senior government advocate for the state respondents. One, 2, 1, 2, 4. 1, 2, 4, Mr. Toppin.
Yes.
1, 2, 4. 1, 2, 4. In this petition under Article 226 of the Constitution of India, the petitioner has challenged the appointment of private respondent number
5 to 30.
5 to 13. 5 to 13, who have been appointed by the respondent authorities on contract basis against a sanctioned post by issuing various appointment orders without any written examination and interview on the basis of pick and choose. No, only on pick and choose policy. Pick and choose policy. And the same is contrary to public appointment. Public appointment. Mr. Lolan, learned counsel for the petitioner, submits that the respondent number 5 to 13 were appointed on contractual basis, and their service has been extended for last
10 years.
10 years. Last 10
Initially,
years,
they were
and their
appointed in the year
appointment is,
2015.
contrary to the principle of public employment and denial of equal opportunity to the petitioner and other eligible candidates,
This is violation of Article 16 and 14 also.
and also violation of Article 14 and 16 of the Constitution of India. The submission of Mr. Lolan needs further consideration. And this is the notice be issued to the respondents, returnable in 4 weeks. Step be taken upon respondent number 5 to 13 by registered post with AD and also by usual process within a week from today. However, no formal notice is required to be issued to the respondent number 1 to 4, since they are represented by Mr. Estapin, learned senior advocate. However, extra requisite copy of the petition will furnish to him during the course of the day. List the matter after 4 weeks.
Lordship, small prayer, the post of the private respondent may be categorized because 5, 6, and 7 have been appointed as divisional accountant officer. And then respondent number 8, 9, 10, 11, and 13 have been appointed as divisional accountant. That may be categorized in the order.
Okay. Respondent number 5,
5, 6, and 7
5, 6, and 7. Okay.
were appointed. Deeply obliged. Lords.
Sama.
Maaf, Ismail.
Sama. Highway, it's not a light away for thank you. 17 US is something. Okay. Yes.
My lord, before applying into the merit of the case, once again, I request to this honorable court. Item number 4 and 5 are analogous matter, and in item number 5, day before yesterday, the government as well as the private respondent has short the time. That is why, yesterday, a report was made that they should be given an opportunity to file their counter affidavit. But it has been unanimously decided by the yesterday, agreed by yesterday that this both the matter should be disposed of today. So matter is ready to dispose today. So in item number 5,
No.
none of the private as well as the respondent authorities had filed their counter affidavit. So this will be disposed along with the item number
So
4.
tell me whether they have filed their affidavit here. Affidavit in opposition.
Yes, in case of item number 4,
Yes,
there's,
they have filed.
yes, actions of pleading has completed.
And in item number 5,
In case of item number 5, they have not filed. Day before yesterday, they showed the time for 2-week time. That I'm trying to display the facts that,
so now you tell me whether we can dispose of that petition without their affidavit.
exactly, my lord, that was my contention. But it is the, my lord, respondent team that they are ready to dispose of the matter without filing their counter affidavit also. So matter is come up today, my lord. Otherwise, since yesterday, I'm,
Whether the affidavit filed by the respondent authorities in item number 4 will cover the case of item number
No.
5 also.
no.
Yes, Madam Ite.
The file has come to my hand this morning on the lordship, this item number 5, lordship, yeah.
You have
I
received
was
the
not
file.
handling this matter,
Pardon?
so I wasn't handling this matter, item number 5. This has come this morning only to me, but then lordship, it seems is the grievance of the petitioner here is also same. Seems to be the same. Identical. If it is so, lordship, the affidavit file here should cover.
Okay.
But
Hello. So the affidavit file in item number 4, along with the file you have received, we can hear and dispose of the matter.
This I have received this morning, this item 5. I wasn't
Okay.
handling this.
So are you ready to argue the matter?
Yes, my lord.
So far, lordship, item number 4 is concerned. I am aware of the facts, but then 5, I have already lordship submitted. This has come to me little before only. So
So till completion of his argument, you go through the file then.
lordship. Yes, lordship.
Therefore, my lord, what I find that even if the argument is started, after going through the certain length of the argument, if matter is came into smoke by taking the time necessary of the filing of affidavit, so this should not happen, my lord. That is why, my lord, I'm just highlight. This is the facts, what going to be disposed of today. So I'm ready to argue the matter in both the case. But what I'm trying to display is that the matter is connected. If item number 5 is disposed of, if item number 5 is disposed of in my favor, my lord, everything will go. This item number 4 will automatically, my lord, fall. There will be nothing to be adjudicated. So I'm ready to display my.
That is not the correct proposition, my lord. Right? If my brother has a personal difficulty of arguing the matter, there is
No, my
another
lord.
thing. The second
No,
thing,
my lord, I'm ready, my lord.
second thing, my lord, the proposition is very simple in this case. In 492, my lord, title suit has already been decided in our favor. Land demarcation was done. And then he also came there and then categorically submitted before the court that we have no grievances against the respondent getting the compensation. So that is so it is his own record, my lord. So therefore, my lord, my respectful prayer would be, if the item 4, that 494, the order is modified to an extent that since he said that there is no, he has no grievances against us getting the compensation, to that extent, if the order is modified, then you can take your own time. The government can also take the time. Because of this frivolous writ petition, the other genuine citizens are not getting the benefit. So that is my extent, my lord. I am prima facie very clear in this case. And item 5, my lord, in the 591, where it has not been disclosed as to under what condition this writ petition was filed. Only making a small amendment saying that the detail of this, in this detail of 30,000 square meter land is still under occupation by the army. So that be the disputed question of fact, Reed court definitely will not go, will not make a roving inquiry, and for him the alternative remedy is there. And then, my lord, that res judicata, estoppel, accusations will always be against him in this case. Item 490, the writ petition 492, my lord. These are settled principle of law. Title is decided. Land has been demarcated. He comes and says before the authorities, we are not against the compensation given to them, subject to the condition that army still occupies some portion of his land that need to be demarcated. And because of this, why I should suffer, my lord? That's the only lease for me, my lord. There's nothing as such. I am ready to argue this matter. And probably, my lord, affidavit filed by the government in this matter also covers.
Yes,
And
madam.
if that is the case, my lord, I just take only 5 minutes in my case. I'll only place 2 annexures where he is being stopped from raising any grievances against me, my lord.
Okay, madam. Alice,
So, this court is also ready to hear the matter, but the question is, nobody should be prejudiced.
Correct.
Tomorrow, after delivery of the judgment, nobody should tell that I have not been given proper opportunity to defend my case.
that's exactly what I'm, my lord, trying to discuss.
Since my lord is presiding the court of equity, so it has to balance the equity in the right royal way, my lord. So that I can understand, so that in legal parlance, my lord, we always use
No,
without.
if we proceed with the matter,
Because in
item
that,
number 4,
My lord, item number 4 may be disposed of today. Let item number 5, my lord, has no grievances against me. His only grievances is that apart from 49.63 acres of the land, the army still is in excess occupation of 30,000 square meters. I think that is your case in the.
In item number 5, also, he has said that until the finalization of ownership, may not discuss the compensation.
How that is?
That has been prayed, just that.
in item number 5.
5,
Yes.
that cannot be permitted, my lord.
So far I have gone through.
Unless a person who has waived his right under oath before the court, saying that
Okay, let us hear, first hear item number
490,
492.
correct.
Okay.
madam.
Yes, you argue the matter.
First of all, my lord, let us see the present impugned order, which is impugned before this honorable court. And I will take the lordship to the page number 135.
Item page number
4.
4.
4. Item number 4. And my lord, The impugn order before this honorable,
Pardon?
impugn order before this honorable court at the instant case, my lord will find in 155, page number 155.
Yes.
So my lord, before entering into the other, this impugn has been passed. I would like to read out it from the second paragraph. Whereas the Honorable High Court in the order dated 17/8/2022 has directed the Deputy Commissioner Wei Xiang Alo to
Page
proceed in
number 184.
154, my lord.
154 miles.
Yes. Yes.
Directed the Deputy Commissioner Wei Xiang District Alo to proceed in the manner as required by the order dated 4/4/2022 in WPC number 131 AP 2022. My lord, it may be kindly recorded that white WPC number 131, according to which it is, my lord, this has been quoted, the operation person of that WPC number 131 has been quoted.
Hmm.
It is for the Deputy Commissioner to give the hearing to the petitioner and determine as to whether the petitioner is the owners of any portion of the land that is acquired. If the result thereof is an affirmative, it is for the Deputy Commissioner to either include the name of the petitioner in the list of the beneficiaries for the compensation, or else it is for the Deputy Commissioner to exclude the land of the petitioner from the acquisition. Whereas the petitioner has provided a sufficient opportunity time in the claim, opportunity to substantiate his claim, and the learned counsel for the petitioner in the last hearing dated such and such has submitted the petition containing the contention and claim of the petitioner, which have been thoroughly examined. After petition submit on 23/9/2022, the main claim on the basis are as follows. The petitioner has claimed that he has procured the army occupied area, locally called the Rago area, and as it's given in 1981 from the Harmo Lowland, the great grandson of the one Quebec Lowland, who was the original owners. Thus, the claim to be owners of the entire any army area. In Basar title case number 3, Kento Ori versus Diga Tatin, the district session court has declared the title of the Hisham area measuring 30,277.85 square meter, approximately 7 acres, in favor of Kento Ori, my lord H. Smith, petitioner. Claim has been claim to have the inclusion of 14.826 acre of his Hisham land in acquired land, that is 49.63 acre. It is pertinent to mention here that no documentary evidence or the witness being produced by the petitioner in support of the claim for the ownership of the Rago area, army occupied area. Further, the claim of the petitioner of having the inclusion of 14.826 acre of the Hisham land in the acre, that is the 49.63 acre, does not hold ground, as the order that the 26/6/2012 in the Basar title suit number clearly stated that the area of petitioner is only 30,227.85 square meter, which is approximately 7 acres. So it's this deputy commissioner also recommended the land of the petitioner is lying around 30,227 square meter. So if the entire Hisham land is full, there is no possibility of inclusion of such acre in the acquired by, that is 49.63 acres. Moreover, this 7 acres of the land is not in the possession of petitioner as he has already sold the most of the land to the various different private individuals who have constructed their permanent residential in the Hisham area, adjoining the army area, and as such, the petitioner has no locus standi to file a claim in objection. In view of the above, in pursuant to the order dated 12/6/2022 in the Basel Title Suit number 59 of 2008, the additional deputy commissioner has confirmed the right and the title in question in favor of the PDB RATAC. My lord, this means this is Panya Bogdo, Panya Dego Bogdo, and Rigo. These are 4 villages. Now they are the respondent number 7. And Alo Township Committee, Boundary Committee. So this term may be known as, my lord, in short, Boundary Committee. And in absence of the strong evidence of the petitioner side, this court is of the opinion that the measuring 69.63 acres belong to the PDBF dwellers, that the petitioner is not owners of any portion of the land is acquired. Therefore, Army authorized are more particularly DO, Itanagar Circle, and the commanding officer for JK LI as well as the DLRSO of the ALO were directed to expedite the land acquisition process accordingly. So, my lord, this has been passed in consequence of the order passed by this honorable court in WPC number 131. This is the 3rd round of the litigation. Now, my lord, before come to the litigation, it need to ascertain. Now, the starting point is that there is a disputed land. That disputed land is under the occupied of the Army, my lord, 5 Mountain Brigade, my lord, at Alo. Now, title suit was, my lord, filed. And accordingly, this title suit was, my lord, withdrawn. And I will take the lordship to the operating portion of the title suit. My lord, may kindly come to the page number 184. I will read out, I will not bother the lordship to read out everything. 184, my lord. My lord, got it?
Yes.
During the course of the hearing of this court, registering the suit of the title suit number such and such, this court notified the parties and WS. Thereafter, many issues were framed and examination of the chiefs and such. During pendency of the cross-examination, the position of the PWS in the chief were furnished in affidavits. The petitioner, Sri Kento, withdraw from contesting in the favor of the Malot 4 villager, boundary committee, Malot. Subsequent to, Malot, this is important according to me, Malot. Subsequent to withdrawal of the contest by the appellant on the settlement of the dispute outside the court, throughout the negotiation in the parties, this court, my lord, the court has revealed that this withdrawal was subsequent to the negotiation of the party, my lord. That point to be, my lord. Noted, my lord. The option left to this court to confirm the title and the land in favor of this, my lord, PDBR at the BC, my lord, boundary committee, village which is occupied under army. In premises above, it is my considered opinion that the single land occupied by the army has not been acquired by the government due to the procedurals of the law as ruled by the Honorable High Court. Now, my lord, may kindly next page 185. Third para, my lord. Third and fourth para. Where, my lord, it said that in view of the above reason, I hereby order and declare that the adequate land compensation again in area of 49.63 acres of the private land shall be paid to the landowners of the, my lord, this committee, landowners of the poor villager, my lord, within reasonable period from the date of this degree and order, without which the area measuring such and such area occupied by the army is the private belonging to PDVRATC villager will revert back its own owners. For the purpose of the brevity, the PDVRATVC village have the liberty to furnish the name of individual beneficiaries before the district administrative deputy commissioner allow for adequate compensation to the individual holding of the ownership and the title area within these acres which are clear as private lands. Meaning is very clear, my lord, while disposing of this title suit, that these private respondents were supposed to return back to the individual owners of the poor villages, particularly the Panya, Dego, Bogdorigo, and Along Township Boundary Committee, my lord. Now, in consequence to this, I will take back to the lordship to what decision had been made be outside, man. In page number 135. This is the compromise wherein, my lord, out of this compromise and the negotiation, my lord, that title suit was withdrawn, my lord.
Yes.
My lord, despite of, my lord, point number 2, my lord. Panya Dego Bogdo Rigo Alo Township Boundary Committee passed and decided and over the 100% Hisham Liburane land to Kentori, and also passed that all the house constructed by the PDBRATC at Hisham are also to be handed over to Kentori. And accordingly, my lord will find in the next page, this para 5, same page, para 5, my lord. And my lord, operating will be 6. All pass the such and such on behalf of the such and such should go to the Basar on the Monday, that is 2nd April 2020, and should withdraw the court of the PDBR versus Kentori, my lord. Accordingly, my lord, by this agreement, my lord, case was withdrawn. The title suit was withdrawn. By this agreement, Hisham area, so-called Hisham is the low-lying area within the army occupied is, my lord, belong to me. 100% of that area has been, my lord, handed over to me, and that is the reason, my lord, this title suit was withdrawn. Now, subsequently, my lord, therefore, in consequence of withdrawal of the title suit, what is remaining is, my lord, the demarcation between my private land and the army occupied area. Therefore, my lord may kindly come to page number 120, my lord.
Yes.
Here in the 120, my lord, it says the demarcation of the boundary in between army and the private land of Sri Kentori located at the Hisham area Alo. And this was notified, my lord, that whereas in reference to the cited above, I am directed to state that the additional district judge court, Western Jin Basar White, number such and such title should number this title should, my lord, of the Hisham colony was directed the office to demarcate the private land in between army and the private land of the Kinto Ori located at the Hisham area Alo. Therefore, you are requested to liaise with the DO Jorhat for the settlement of their representative port, carrying out their joint verification demarcation of the land as stated above, and tentative date of the verification is fixed on 24/9/2012. Meaning thereby, my lord, after the withdrawal of the title suit, the boundary between me and the army occupied land was supposed to be demarcated, but my submission is that till as on today, my lord, this demarcation has not been done. Now, my lord, 123, my lord. Continuation to page 123. Here, my lord, another representation has been placed on 2021, wherein, my lord, I have narrated all what had happened, my lord, that and operating will be, my lord, may kindly come to 125. Because despite of reading in this representation, everything has been explained. But what is my prayer, my lord? 125, my lord, got it? That it is to pray before your good office for the comply of the Deputy Commissioner Court judgment on 21/8/1999 and this Honorable High Court order that is such and such in regard the demarcation of the boundary in between the Hisham village area and the Rago area occupied, which already been fixed boundary. And in the DC Court judgment, in the High Court judgment, it is clearly mentioned that the down and the low sloping area pole under the Hisham area and up to the plain area pole under the army till the army has not shifted to the another place. But due to the recent army map has drawn by the district administration and the army has encroached the occupied downside slope area, Hisham area into their area. As such, I am praying before your good office to immediately cancellation of the present army map and until the army and the BRT has not been removed from my Ragorapik area. My lord, one thing to be, my lord, keep in mind this Ragorapik area and the Hisham, these are the, my lord, same area. I may be allowed to peacefully farming in the down slope area of the Hisham village area, which is presently occupied by the army. Therefore, I am filing this application for the bona fide and seek for the end of justice under the posted facts and circumstances. It is highly prayed that the good office be pleased to admit this application. My lord is still it was in the years 2021 and still my prayer is going on that the demarcation should have been made between the army occupied and the land which has been handed over to me by the other party. Meaning thereby still the some portion of the land is attached within the occupied of the army area, my lord. Now, my lord, in due course of time, now it has been established that the demarcation between the army and my private land has not been settled till today, my lord. In due course of the time, what happened, my lord? This notification under section 11(2) of this, my lord, right to fair compensation and transparency in the land acquisition rehabilitation was notified, and I will take the lordship to this notification. And page 126, my lord. Here, my lord, I surprised to find this under section 11(1) of this, my lord, notification has been made, whereby, my lord, this respondent number 7, represented by this respondent number 7, 9% of this, my lord, particular person has been made as a beneficiaries, whereas as per the my lord direction of the session court in the title suit, the yes, FTC court, this boundary committee, they were supposed to, my lord, distribute back to the landowners, individual owners. Now they become, my lord, landowners. That is the, my lord, the main reason why I have contested and why I was, my lord, filed objection against the, my lord, this notification. And this notification, my lord, under section 12, my lord, that I have objected. Now, epicenter of this case now start with here, that while I have filed the objection, my lord, I was not allowed to represent by the any council, my lord, whereas the order has been passed. So the first order was passed by the deputy commissioner on fourteen 12/2021, whereby, my lord, deputy commissioner, basing on the title suit, my claim was rejected. Therefore, I approached this honorable court through the, my lord, YWPC number 394. And by 394, my lord, the order passed by the deputy commissioner was set aside, and I will take the lordship to the page number 196. The first impugn order, my lord. This is the third round of the litigation in the present case. But the deputy commissioner has passed the same thing again and again, my lord. 196, kindly come to page 196, my lord.
Yes.
It is start from 191. And
Okay.
198,
Come to the operative portion.
192, my lord. I'll take the operative portion, my lord. Operative portion is 196, my lord.
Yes.
Whereby, my lord, is 11, my lord. Consequently, the impugn order dated 12/12/2021 passed by the Deputy Commissioner, West Siang District, Alo, wide number such and such, stand set aside in quas to enable the Deputy Commissioner, West Siang District, Alo, to pass a press order in the matter after affording the adequate opportunity of hearing to both the parties as indicated above. Therefore, my lord, the order passed by the Deputy Commissioner on 14th, this previous order passed by the Deputy Commissioner has been set aside by this honorable court and given an opportunity to the Deputy Commissioner to pass a press order. In consequence of this, my lord, in pursuant to this order, after hearing of that, another order was passed. My lord, may kindly come to the page number 197.
Yes.
The order has been, my lord, simply repeated. 197 to 198, my lord. The same has been repeated. Therefore, my lord, I was compelled to approach this honorable court by YWPC 131 2022 for second round of the litigation. In the second round of the litigation also, my lord will find the page number 2. It starts from 199 and 204, and my lord may kindly come to page number 202. This observation has made by this honorable court. My lord, 202, para 7. This court already observed that we are unable to understand as to why the respondent number 7, being the secretary of the PDB RATBC, is to be given a hearing in the manner and the petitioner claim is a private land has been included in the acquisition of, but his name is not included in the list of the beneficiaries. A secretary of the organization cannot be the owners of any land unless it is the case of the respondent number 7, Sri Sasan says that he who is the owners of the land over who is the petitioner is making claim in my lord. This court has already observed, and accordingly, my lord, the direction was made to take up the de novo, my lord, in 203, my lord, page para 9. Yes. Here it said, my lord, on the other hand, the respondent number 7 in the new that it is the who is the owner is again the deputy commissioner to give the hearing and determine on the ownership of the respondent number 7, and the other approach would be appreciable on the part of the deputy commissioner other than to determine the legal right and the writ petition for which he has needfully indicated above. On the other hand, if the respondent number 7 is the owners, the deputy commissioner may determine in the appropriate manner. Accordingly, we remand back the matter to the deputy commissioner for fresh consideration as stated above. In the de novo determination, the deputy commissioner shall determine, firstly, my lord, whether the claim of the petitioner that he is the owner is correct or not, and for the purpose of the deputy commissioner shall provide the petitioner with every opportunity to substantiate his claim. On the other hand, if the deputy respondent number 7, who is also required to make a claim that he is the owner, the deputy commissioner may also determine the same, and depending on the determination, an appropriate order be passed. My lord, that is there, and accordingly, my lord, page 204, the period of this, the time was given, and period of the 1 month from the date of receipt of the certified copy of the order. Any order to be passed shall be superseded and hold the precedent over the earlier order that 17/3/2002 till determination is done by the deputy order shall be, my lord, shall not be given effective. So this is the second time, my lord, the order of the deputy commissioner has been, my lord, caused by this honorable court and sent back to the deputy commissioner. And deputy commissioner, my lord, passing the same order that he has, that the petitioner have no land, my lord. Now, in consequence of this, my lord, neither the deputy commissioner whole hearing, my lord, that was the hearing took place in the High Court for many days. Hearing took place before the deputy commissioner for many days, but neither the deputy commissioner nor the private respondent has able to show the reason why these 9 persons become the landowners, whereas they are the committee. As per direction in the title suit, they are supposed to hand over to give back to the original people of that 4 villages. Therefore, my lord, on my recent inquiry, I come to know that land ownership certificate has been issued to these 9 persons on, my lord, in page number 205 last one. 18 July 2019, my lord. This person have this and this, this person have this and this. This has been given. On my further inquiry that how it's come, my lord, the land ownership certificate how this has come to these private respondent, my lord. In my inquiry through the RTI, my lord, I come to know that there was a meeting which was attended by the 20 members, out of where, my lord, 7 was the GB, and others is that these members which appear in page number 205, and the other officer. That particular minute was, my lord, passed on 16 July 2019, my lord. Now this is the main weapon, what we can say, my lord, the MiG-29 and rappel of this respondent team, my lord. This is the weapon where this has been hidden till today. Even in the reply of the private respondent, this has not been, my lord, reflected. So that at the last moment, they could bombarding upon us, man, upon me, man. Now in subsequent to this, now the position of this court has, my lord, come until and unless I challenge the particular order where the land ownership has been issued to the private respondent, that also within the, my lord, period of the 2 days. Therefore, my lord, by the writ petition number 591, I am challenged this particular order, my lord, in page number 205. How this has been, my lord? Because as everyone know that, my lord, in order to get the land possession certificate and the land ownership certificate, my lord, there is certain procedure is required. But without maintaining the procedure, this has been allowed, and now this become precedent, and the notification under section 11 is brought to this order, my lord. Therefore, to give the fair compensation, if notification is made to be acquired by the army or to be acquired by the, my lord, central government, first of all, they should, my lord, notice, and what it is said that in the notice, my lord, there should be properly published. But here in this case, my lord, it has displayed that 9 persons has already been, my lord, made as a landowner by the minutes of the meeting. And this court has already observed that being the members, being the boundary committee members, you cannot be the members of how you come that this, you become the landowners. Now, my lord, that is why, since yesterday I have been saying, my lord, when I am challenging the process, how these 9 members, private respondent, become the beneficiaries in place of the poor villages, whereby, my lord, approximately what I cannot say exactly, my lord, approximately there should have been, my lord, 2,000 to 3,000 population, my lord, in the poor villages. They have been paid for, meaning thereby, my lord, they were the marks for the interest of the public for Alo Township, and when they come to know that the some portion of the land has not been allotted to the government, acquired by the government, now the committee became the, my lord, land owners, man. Therefore, by the subsequent writ petition, I am challenging the process adopted by the deputy commissioner that this should not have been, my lord. Before notification of the section 11, they have already prepared and made them as a landowner, and thereby notice is made, my lord. Therefore, till today, the status of the case is that under section 12, my objection against these beneficiaries is yet to clear, me. That is why, my lord, time and again I am saying that they need to file. Now, since they are not ready to file against the WPC number 591, Now, on what basis? They cannot, my lord, on what basis? Their oral argument will, my lord, not suffice. Therefore, I am saying that if I am succeed in WPC number 591, quashing the allotment to the 9 private, where will be the, my lord, position of beneficiary, my lord? That is why, my lord, I am very honestly, I am giving an opportunity to them to file their counter affidavit if they are ready to contest. But now, unanimously, yesterday, this has been decided that they are ready to dispose of the matter together. Meaning, my lord, now I will come to, my lord, the next WPC, my lord. So this item number 2. So if I able to quash the land ownership certificate issued by the Deputy Commissioner to the 9 respondent, my lord, as a beneficiaries, where the case remain, my lord, that the observation of the Deputy Commissioner is only that I am to, my lord, repeat some essential, this main point, my lord. Facts simply, Deputy Commissioner has denied that you have withdrawn the title suit. I never challenged. I admit I have withdrawn the title suit on the ground that the Hisham has been allotted to me. Now my question is, the Hisham portion where I have been 100% allotted to me is under the occupation of the army area, my lord. This was already been settled, yes. Okay. It was already settled in 2000, my lord. 1999, my lord. And for this, I will take the lordship to have a glance over the page number 93, man.
The present petition.
Yes, 93. This was already been decided. It is there from 92. My lord, I'll read out the 93 only. Got it, my lord? 93. In para 7, it is also found and informed that during the years 1987, Sri Tawam Ba, the ADC, the then ADC, Alo visited the said demarcation area is found that the cement pillar as well as the hijo trees are still exist, and accordingly the sketch map prepared. But due to the sudden demise or transfer from Alo, the issue could not settle and still remain unattended. On 28/7/1999, 9 members of Dego Panya Bogdo Rigo villagers and Sri Tapang Taku, ex-PA, and Sri Mindep, the ex-PA, were heard in connection with the boundary of the Alo Township and above the village. All the 9 members have unanimously delivered the same view as pointed out above. On examination of their statement, it is revealed and found that the low sloping area of the army occupied area as well as the present Hisham village are not a government land, and these lands are belong to the private land of the Malot, Dego, Panya, and Bogdo village, Malot, which they call now boundary committee. Hence, the sketch map showing the boundary demarcation of the Alo Township and the Dego, Panya, Bogdo village is required to be prepared based on the point to avoid the complication in the picture about the Alo Township. So, my lord, this particular order has been relied by this honorable court in the various writ petition also. Meaning thereby, my lord, since 1991 and since 1999, the area has been undisputedly cleared that the so-called Hisham, the down low area, is belong to, my lord, this Dego Panyabogdo, these respondents also. Now the respondent number 7. And by the agreement of 13 or 30 December that I have shown to this court, by the agreement of that, total area has been, my lord, handed over to me. That is why only my contention is that since some portion of my land is occupied by the army, why the army has not demarcated the land? Now, in this case, my lord, army has denied to reply, my lord. Appearing on behalf of the army, denied to reply, central denied to reply, my lord. So, my lord, undisputedly, some portion of my land is still within the army occupied area at the Hisham area. Therefore, honestly, I am praying that if I am not included in the beneficiary list, my area may be carved out by conducting, my lord, the demarcation. Since that demarcation was already been made in that, my lord, in this 1987. Now the subsequent issue has, my lord, now arises. These 9 members who had already handed over to me the solo down portion known as Hisham, now they become the, my lord, beneficiaries by the order dated, by the order dated 18 July 2019, passed by the Deputy Commissioner. So I am here challenging them, my lord, how they become the beneficiaries without hearing to me. That is why, my lord, I am saying that if WPC number 591 is disposed of in my favor, my lord, the question of beneficiaries in the, my lord, item number 4 will definitely fall. And I am repeating again, I am honestly giving them opportunity to reply. But when they are not ready to file, when they are ready to skip their filing of the affidavit in opposition, this court has nothing but to accept that they have nothing to file. In item number 2 also, Deputy Commissioner was adamant not to file, not to explain. But by the this honorable court has given the last chance and third last chance, when the possibility of contempt against the Deputy Commissioner was reflected, then only now they file. Now, my lord, I will come to the, my lord, reply first, since the reply was filed by the respondent, private respondent. Private respondent has taken the same situation only by saying that you have lost by withdrawal your title suit in the Vassar, and on support of the support of it, they filed some document showing that, my lord, in document they have showing that I have sold some portion of the land at Hisham, my lord. Wherein, my lord, they have shown that I have sold some portion of the Hisham to the 6th person, my lord. And I admitted, my lord, yes, the person who is not occupied by the army I have sold. And I thanks to this private respondent, they helped me that because the Hisham is within my possession and undisputed, so I have sold. And even if we calculate also, the court clearly revealed that in the Hisham, 30,227.85 square meter is there, according to the court. And if the private respondent able to show that I have, so per my calculation that 1,795 square meter has been shown. Despite of that also still, my lord, 28,468 square meter is, my lord, undisputedly within my possession. But I am not here that this area should be, my lord, compensated to me. I have the limited objection that despite of my land donated, my land surrendered by you in consideration of withdrawal of the title suit, that land is under the possession of the army, now under possession of this army 5 mountain brigade, my lord. It has been calculated 49.63 acres. Therefore, if Deputy Commissioner establish or find out how much of my land is still under the occupied of the army, my lord, then the notification, my lord, that may not be 49.63, my lord. Now, therefore, there is affidavit of the respondent 7 has, my lord, nothing to prove to show. Even, my lord, they bother to give that how they have been, my lord, allotted and why they become the landowners, my lord. That has not been even explained. That is why I said that, my lord, the main weapon of the respondent they have been hiding. That is why I am challenged here. Even they have not displayed that out of the land possession certificate issued to them by the Deputy Commissioner, they are now right to claim over the army possessed area, army occupied area. Therefore, my lord, the reply of the respondent number 7 is noting, my lord, noting displayed that they could establish within the army occupied is belong to them. Only, my lord, they have, what they have used is only that by the Basar title suit you have withdrawn and that has been surrendered to the 4 villages. And I never disputed. Exactly that was happened. In consequence to that, they were supposed to find out the individual out of the 4 villages who are the owners within that land. But despite of that, immediately they became the landowners, beneficiaries. This High Court in WPC 131 has already observed that the High Court also failed to understand why the committee became the landowner. Now, in the reply of the government, by forcing the government has now replied. And the contention of the government is also same. Government here, my lord, the Deputy Commissioner. The Deputy Commissioner is also relied that these 9 members, respondent, become the landowners, they became the beneficiaries because the land ownership certificate has been issued to them. That they have realized, my lord. And other than that, my lord, no noting. Now, one thing, my lord, page number 56, what the Deputy Commissioner has relied that, page number 56, my lord, this is the affidavit in opposition filed by respondent number 3 and 5. They said that there was a public hearing. On basis of the public hearing, these 9 members became the landowners.
Number 56 and Annexure C.
My lord?
Annexure C.
My lord, this should be, yes, Annexure C, 56, government, my lord. 56, huh? My lord got it, 56?
Yes, yes.
Because of this, my lord, minutes of public hearing, which was conducted on 16/7/2019. And if my lord go through if my lord, we can find that the person present was first DLR Shaw. Second is the Lieutenant Colonel, my lord. And it start from 3 to 8 are the GBs. And the rest are, my lord, these private respondents. By this decision, my lord, they become the landowners for 49.63 acres, and thereby, my lord, in subsequent to this minutes of the meeting that 16/7/2019, the land ownership certificate was issued to 18/7/2017. It's appear in page number 67. My lord. Therefore, my lord, I have question in the next WPC, my lord. Within 2 days from the date of my lord decision, they became the my lord. This has been issued. And so far, my lord, everyone know to acquire the land ownership certificate, to acquire the land possession certificate, my lord, it takes a number of days. And the my lord, there are certain procedural to be maintained, whether the location is required, and there is a particular form to be filled up, and the adjacent need to be signed. This type of all procedure has not been maintained, man. In a whose manner, within a 2 days, my lord, this has been, they have been given an opportunity, there has been, my lord, made as the ownership, and thereby, my lord, they become the ownership or beneficiaries. And particular now, my lord, after prepare this only, in years 2021, that the notification was issued that these person are going to be, my lord, compensate. That is the reason that I have objected. And now, my lord, after certain hearings and the previous occasion, my lord, that it has come to this court that until and unless the specific particular challenge to the proceeding of the land ownership certificate issued to the private respondents by the Deputy Commissioner is not challenged, this honorable court will helpless to interfere. That is why I am challenging by 5 WPC 59, which is in serial item number 5. So if they are not ready to file any objection or not ready to contest in item number 5, my lord, nothing left. I don't think, my lord, the verbal submission of the respondent will convince this honorable court that this land allotment, land ownership certificate issued to the private respondent by the Deputy Commissioner is genuine, and this has been done. And even if this, my submission would be, my lord, and the argument point of my view, even if the respondent will successfully able to, my lord, establish that this has been their procedure of issuing the land ownership certificate to the private respondent will be established, my lord, I cannot accept, my lord, on the ground that, my lord, how far their verbal submission will be covered to this case, my lord. They need to file. And when they escape, they ready, when they admitted not to file, my lord. In such situation, in item number 5, this court has to interpret the order passed by the deputy commissioner and set aside
No, no.
and need to quash.
File is available with her. She can
My
advance
lord.
her argument on the basis of the file.
Yeah. So, my lord, therefore, to this extent, just to conclude, my lord, and subject to reply, if necessary, my lord.
Hmm.
My submission is, my lord, that's my prayer, humble prayer before this honorable court. In item number 5, the order passed by the deputy commissioner, minute of meeting without hearing to the public by calling the particular person, especially to the private respondent as a beneficiaries on dated 16 July 2019 and the subsequent land ownership certificate issued to them on 18 July 2019 be quashed. My lord, this can be quashed by this honorable court only because this has been passed by the deputy commissioner. So, my lord, if it is quashed, the question of the beneficiaries to the 9 private respondent, my lord, has gone. So it's automatically, my lord, this item number 4 will be, my lord, covered, my lord. Even if the deputy commissioner, even they deny, if this allowed ownership certificate is quashed, my lord, nothing will remain. So let this 2 order be quashed and sent back to the matter to deputy commissioner to ascertain the facts, my lord, to ascertain my claim. That must, my lord, and subject to reply, my lord.
Well, normally, the government has to answer first,
Hmm.
but I have some difficulty after 2 o'clock, Miller.
Hmm.
I seek the kind indulgence to grant me leave to.
Okay, all right.
Yeah. Answer.
Lordship here, but then I have a second lordship this one. Because we have not filed reply in the 491.
Hmm.
And there are certain
Right.
questions to be answered by the deputy commissioners. The burden is on the deputy commissioner also mainly.
Hmm.
So
Well, just when the hearing started, we took a decision for completion of 492 only.
Hmm.
So 492, and then whatever consequences it comes, consequences will follow. If we succeed, that's fine. Miller.
Hmm.
So only to this extent only, because my brother is trying to connect, but there is a disjunction also, which I'll do it.
Hmm.
Just I'll do it.
Hmm.
Well, I had heard the argument of my brother for nearly half an hour. After listening to him, Miller, I find a thought came to my mind. My brother tried to convince that I never wanted to argue. I just wanted you to understand how I felt.
Hmm.
That is the sense my friend Modi tried to convey. However, the writer Milot in this thing is another thought that come to my mind after listening to him is Confucius now had made his masterpiece, because he was trying to juxtapose between the 2 facts, trying to connect and confuse the fact on law and malice, my lord. Even, my lord, the cursory reading into the whole argument, my lord, will find the fact has distortedly been presented in this case. My lord. The fact is, my lord, there was a land acquisition in 1962 by the army. Then title suit decided in the Basar case, 49.63, which he has not challenging. What he was trying to confuse is 2008, my lord. How the land was, how this No. Page 147, my lord, will come. He's just trying to confuse the court. On fact, my lord. My lord, kindly see this, page 147. This title suit was withdrawn, which he referred to, dated 12 June 2012. This is nothing to do with the decreed land of 49.63 million. Where is the title suit? Then for clarity, my lord will kindly come to page 171, my lord.
Yes.
It is their case where the land has been decreed. And here, my lord, we were not the
Page
party.
number 71 is the
170.
order.
170.
17.
170 was title suit.
Yes,
So this is,
petition there.
yes.
Paragraph number.
I said, the judgment decreed. This is the judgment which has decreed for
Page number 17 of the
49.63.
judgment.
Yes. 49.63 was decreed in favor of the respondents. So therefore, my lord, there is a complete disjunction of the fact what my friend has referred to, which was withdrawn in 2012. Okay.
So this title suit was withdrawn.
That 2012 title suit was withdrawn, which he was referring to. So, but then primarily, my concern is that Basar title suit, my lord, where 49.63 is decreed in our favor. And that is still in existence, my lord.
That title suit is page number.
Yes, Fido. It is in my affidavit, I suppose. Huh? Page 147, my lord.
Where it is mentioned about withdrawal.
Withdrawal का है? No, ये तो withdrawal नहीं था, no. This is decreed in our favor. This is withdrawal. That's, my lord will kindly come. The operating portion is where is it? No, this is one. Let me see this. This I have not marked. Page 147. This is what? This is your reply. This is his reply. Right? No, this is the repetitions.
Oh.
Correct, Milo. Kindly come to page 147. Withdraw Manamukar. This 147 is the withdrawal one. Sir? Will kindly come to 150, the operations portion. 1, 2, 3, 4, 5.
Page number 1.
50.
Yes.
This is the operation person is
Hmm.
1, 2, 3, 4th paragraph. During the pendency of the cross-examination of the position of PWs in chief which were furnished in affidavit, the petitioner Sri Kento Ori withdrew from contesting the case in favor of PDR-ATBC villages.
Hmm.
Meaning thereby, Milord, that Basar title suit number kaun sa tha all wala. Just find out. Page 147. नहीं, see माने. Decree wala. 171, my lord. Kindly come to 171 for clarity. My lord. That is annexure E of his read petition. My lord.
Yes.
Now, my lord, the operating person, my lord, will find is at 179.
Yes.
179, my lord, there is, in the light of above reasons and on withdrawal of the respondents from the contest in the present suit, I am of the considered view that the Isam land is absolutely a private land of Sri Kento Ori. And in the resultant, I hereby decree that the title to the said land is absolutely confirmed in favor of Sri Kento Ori, along with possession, occupation, interest measuring an area of 30,227.85 square meter. Here, my lord, it is very loud and clear on fact. $30,227.85 square meters of land, my lord. Excluding ours, 49.63.
Is it mentioned there?
Yes, my lord. Now, next, my lord, kindly come to his own case only, my lord. Page 185, that annexure F, my lord. Basal title 9, title suit 5908, my lord.
Hmm.
I'll not quarrel whether he has a land or not, that I will not dispute, my lord. What is there in the record, my lord? He cannot make us party, my lord, because he cannot have any grievances against us. If there is any grievances, my lord, Reed Court is not the forum where he can seek relief against us, my lord. Annexure F, my lord, 181, my lord.
Hmm.
Here, my lord, will see that page operating portion is at 185, my lord. Para 2, my lord.
Yes.
In view of the above reasons, I hereby order and decree that the adequate land compensation against an area of 49.63 acres of private land shall be paid to the landowners of the PDR-ATBC villages within a reasonable time period from the date of this decree and order, without which the area measuring 49.63 acres occupied by army, which is private land belonging to the PDBR-ATBC villagers, will revert back to its owner. My brother was trying to confuse me, lord. In the earlier title suit, my lord, clearly says he has 30,227 square meters of land.
Hmm.
But he is trying to connect my case, my lord. Is it permissible in law, my lord?
Hmm.
Not permissible even in the fact, my lord. My lord, law of evidence, the nature that we know, my lord. What is the prudence rule of evidence? How you dare to connect me, my lord? This is the question coming to us. This is my land. the notification was issued in respect of preliminary notification, land acquisition was issued in respect of 49.63, not with respect to the 30,227 acres, that is 7 acres of land, which is still in possession of Mr. Kento Ori. He is trying to confuse with my case, my lord. Now, my lord, this is the reason why I have said yesterday categorically, unless you don't challenge this, and moreover, you have already withdrawn that earlier title suit, you cannot have any grievances against me, my lord. Now, my lord, to fortify my argument, I will place 1 document, my lord. 2 documents I will place, my lord. My lord, kindly come to page 191. I'll not take much time, another 5 minutes. There is no confusion, my lord, with regard to this particular case, my lord. So therefore, I insisted that 591 has no locus to challenge my thing, my lord.
Okay, 190.
191, my lord. Matter of claim and objections.
Hmm.
My lord, kindly see next second paragraph, my lord. He has waived his right. On the very outset, Sri Kento Ori stated that he has no issue with the PDBRATBC getting the land compensation, and also that he is not claiming the title of land occupied by army. His only grievances is that in the land map of the army occupied area, his private land at Hisam village is included and the same should be carved out. Now, my lord, that this Pagdo, they go, no? This PDB area and Hisam is another thing altogether. These are different places. Somehow, somewhere we are being dragged into unnecessarily, my lord. So this is just I have fortified my argument, my lord. Kindly see, he has waived his right from the title suit number 58 and this particular order dated 02/12/2021. And another thing, my lord, where he has waived his right is page 197, my lord. Kindly see. That is by order dated 17/3/2022.
$197.
190, yes, my lord. Page 197, Annexure K, order dated 17/3/2022, my lord.
Yes.
My lord, I read 2 paragraphs, a small 2 paragraph. Paragraph 3rd, my lord. Paragraph 3 said, both the parties appeared before the Deputy Commissioner, West Siang District Alo on 3/2/2022 and date of hearing was fixed on 23/2/2022. However, the counsel for the petitioner prayed for adjournment of the hearing fixed on 23/02/2022 due to his preoccupation. The hearing was refixed on 4/3/2022. Now, my next paragraph, kindly see. My brother Modi was there, I think, like, on that day. Kindly see my next third para. The counsel for the petitioner submitted that his client is not demanding compensation for 49.63 acres of, kindly mark this, my lord, of land to be acquired for army, but is confined with the demarcation of land stroke boundary to be cleared between army occupied area and the private land of Sri Kento A.C. Ori at Hisam site, my lord. On 2 count, my lord, categorically he made a submissions. It is reflected in the quasi-judicial order, meaning thereby all the pleading against me is misplaced and misdirected. So therefore, my lord, my respectful submission is the accusations, the waiver, the estoppel, all the doctrines and its consequential legal principles will come against him, my lord. You are stopped from raising against me. You do not have any grievances against me except with the army, my lord. If the army is in occupation of your land, please you go and file title suit. 2, 3, my lord, has seen from the pleading itself, my lord. He was trying to take a zigzag road, and that zigzag unnecessarily we have been dragged in. For what and why? You could not give any plausible explanation to your actions. When you have waived, when there is a estoppel against you, till you challenge that Basel titles of judgment, how you can have a grievances against me? My lord, kindly see that notification, preliminary notifications for a moment.
Page number?
That 187, my lord, preliminary notifications. 187, eh? Huh. This is further to fortify my argument, my lord. My lord will kindly come. Order dated 16 August 2021. Para 3. After preliminary notification, my lord, paragraph 2. Whereas it appears to the governor of Arunachal Pradesh that the land is likely to be needed at the locality more fully described in the schedule below for establishment of interim brigade headquarters on an area measuring 49.63 acres located at Bogdo, West Siang district. My lord, kindly see, it is against the decreed land only. Isam nowhere comes. Isam is another land. Alternatively, I can say that 30,227 square meter of land, right? Accumulating to 7 acres. Prama facie from the records, my lord, appears to be still in his occupation, and probably it might be with the, probably the army might be in occupation of that land. And this becomes a disputed question of facts. Disputed question of facts, my lord, cannot be brought into here. This need a regular trial to adjudicate, my lord. The sum and substance, my lord, all those land, my lord, whatever he has had, has already been sold out by him, my lord. Kindly come to page 15 of my affidavit in opposition, my lord. I have categorically made a description, my lord. My lord, it's 2 o'clock. I'll just come back for another 5 minutes and then I go, my lord.
No, at 2 p.m. We have some matter. Additional Solicitor General will appear. Yes. From Delhi through VC.
We continue tomorrow then, my lord.
Then tomorrow.
Tomorrow we continue that. But sum and substance, my case, my lord, therefore, if his grievances is against the army only, not even to the government. The government also doesn't have anything now. Because there is a decree already. In the decree judgment, he has to fight out with the army, not with us, my lord. Anyway, my lord, we'll come back tomorrow.
Yes.
Yes.
Third is the OD learned counsel for the petitioner. Mr. Titara, learned counsel for the respondent number 7, and Madam Ite for respondent number 1, 2, 5, 1, 2, 5, and you for 4 and 6. 4 and 6. 4 and 6.
Great.
List the matter tomorrow as part of.
Yes.
Along with that, other repetition also. If she can argue the matter.
Once this my thing comes, with the argument that I'm concluding tomorrow, then that he has no locus against me in that petition.
No, no. Our endeavor is to dispose of both the matter, not only your matter.
Correct, correct.
Apologies, my lord, some personal emergency came up. I beg to mention item number 12. In the last order, opportunity was given to the respondents to file their affidavit, but they have not filed, therefore it may be fixed for admission hearing.
Item
Next.
number 12.
Yes, my lord.
Okay. On the appearing made by Mr.
Mukbang Curtin.
Learned counsel for the petitioner with consent from the other side. This is the matter after
1 week
after
for admission hearing, my lord.
for admission hearing.
Much obliged.
Okay.
Your Lordship, I would like to mention item number 7.
7.
Yes, Your Lordship. We have taken consent from the other parties, Your Lordship. The matter may be listed after 4 weeks.
When do we list it?
Yes, my lord.
When?
After 4 weeks. Your Lordship.
4 weeks.
Yes, Lordship.
Mr. Your good name?
K. Terry.
With Mr. Swinson, learned counsel for the petitioner with consent from the other side. As for listing the matter after 4 weeks. Fair look. 19 or 19.
Your Lordship, also I would like to mention item number 6, Your Lordship.
Item number?
6.
Similar order. Okay.
No, Your Lordship, if it's, then Your Lordship, the matter may be for fixed date, Your.
Pardon?
Item number 6.
Yes.
If it's on a fixed date, Your Lordship, on 26th of this month.
26.
Much obliged.
May I please?
Yeah.
I will mention item number 9. Finally, this matter may be passed over for a day, Your Lordship. I have the consent of the counsel for the petitioner. Your Lordship.
Okay, Mr. Your good name?
Ivan, Your Lordship.
Item learned counsel for the petitioner with consent from the other side. As for stand over the matter for the day. Fair look.
Lord's matter may be fixed tomorrow.
Tomorrow.
Tomorrow. Pass over for a
Okay.
day.
Okay.
Much obliged.
May I please, madam? Item 19, hearing item. This matter may be taken up tomorrow, my lord.
Mr. Zitar, learned counsel for the petitioner with consent from the other side. As for listening the matter tomorrow.
Okay.
Fair look.
May I, Your Honor? Your Lordship, item number 18, I would like to mention.
Okay.
I am appearing for respondent number 3,
Okay.
and I would like to file affidavit in opposition, so I may be given some time.
Okay, Mr. Your good name?
Maybe
Your good name?
K. Tasso.
Learned counsel for the respondent number?
Item number 18, respondent number 3.
Respondent number 3.
Yes.
You will inform
I
the
have-
other side
Yes, sir.
with consent from the other side?
Yes, he's present.
Right for listening the matter.
3 weeks.
So as to enable him to file affidavit in opposition. Fair look.
May, my lord.
Published.
Item number 20, item 20, 21, but
Okay.
can it be listed on 16th of June?
16th of June.
Yes, she's for the petition.
For the petition, Your Lordship.
Heard Miss Ann Anjo, learned counsel for the petition, and Mr. B. Pisa. Learned standing counsel for respondent number.
No, private respondent.
Oh, private respondent.
Yes, ma'am.
Private respondent. Private respondent number, what is the number?
3.
3, my lord.
3. Mr. Pisa, press for listing the matter on
16, my lord.
16th of June.
My
Fair.
Lordship, there is an interim that may be continued.
Both the matter?
Yes, Your Lordship.
Interim order passerly shall continue.
Obliged.
May I please, Your Lordship? I beg to mention item number 11, Your Lordship. Here, Your Lordship, on the last order, I have directed to take a step to the private respondent number 4.
Yes.
And accordingly, I have filed an affidavit for service upon the respondent number 4.
Okay.
So Lordship, matter may be fixed for admission hearing after 2 weeks.
Okay. Mr. Your good name, please.
B. Ori.
Learned counsel for the petitioner. You inform the other side?
Pardon, Your Lordship.
You inform the other side
Yes, Lordship.
with consent from the other side, plus for listing the matter on
2 weeks, Your Lordship.
after 2 weeks. Where is accordingly allowed, recess shall list the matter in admission column
Yes,
after
Your
2
Lordship.
weeks. Okay.
Oblige, Your Lordship. Your Lordship, I have taken the step to the private respondent number 4 to be reflected on the order, Your
Go
Lordship.
for private respondent.
Private respondent number 4. I have filed an affidavit, Dusty, to the respondent number 4, private respondent number 4.
You are not the petitioner's counsel.
I am the petitioner, Your Lordship.
That's all right.
Yeah,
Such is completed, therefore you have prayed for listing the matter for admission here.
yes.
My lord. I beg to mention item number 8, my lord. This matter is listed on 12th. I've taken consent from the petitioner.
Nice one more, Lord Government Advocate, for the respondent number,
1 to 4.
with consent from the other side, rest for listing the matter on
12th month.
12 zone.
Yes.
Okay, fair, Lord.
My lord, additional Solicitor General, he has already come in the VC, my lord. And prior to that, my lord, just prior to that, he has forwarded a synopsis of today's argument and for your lordship.
Okay.
My lords, we have filed one application, my lord, for extension of time. My lords, am I audible, my lords?
Yes, yes.
Lordships. Now, my lords, this honorable court, honorable single judge of this honorable court, my lord, by the order dated 12/3/2025, in respect of our interlocutory application, my lords, seeking stay of the, my lord, judgment of the reference court, passed the order, my lords, granting stay with a direction to deposit half of the enhanced compensation amount within 3 months, my lord. Now, my lords, that 3 months is expiring on 10th June. So we have filed an application for extension for 2 reasons, my lord. Because, my lord, this amount was very huge. That was more than 200 crores. So we had to take permission from the higher authorities to take a decision on the issue. And number 2, that we also wrote to the Deputy Commissioner, my lords, for the purpose of calculation of enhanced amount and then half of the enhanced amount, so that the matter may be sent for consideration to the government authorities. But if your lordship will see our IA, my lords, which we have filed, my lord, that IA, my lords, your lordship will find.
What is the number?
142.
IA 142 of
142.
My lords got it, my lords?
Yes.
Your lordships. Now, my lords, if your lordship will kindly see paragraph 3 and 4 is important. Lordship will permit me to place it, my lords. Lord, at page 30.
Yes.
Your lordships, Lord, that after passing of the order dated 12/3/25, the defense estate officer applied for and obtained a copy of the order and forwarded to its higher authorities for their consideration. Further, since the amount is very huge, being more than 200 crores, Lord, it comes to 218 crores. Now, therefore, the matter is under consideration of the higher authorities to avail remedy against the interim order before the Honorable Supreme Court after taking opinion from the Ministry of Law and Justice. The higher authorities, after considering the entire matter in detail, found that the decree has been fraudulently obtained by the power of attorney holder, and therefore the decision to deposit can be taken only after the opinion from the law ministry and the law officer of the government of India is received. Then, my lord, paragraph 4 is more important, that it is stated that Defence State Officer Itanagar had requested the Deputy Commissioner Lipada to provide updated enhanced compensation calculation sheet in compliance with this Honorable Court order dated 12/3/25 for taking further course of action in the matter. Accordingly, the Deputy Commissioner Liparda has recently forwarded the updated enhanced compensation estimate amount to the Defence State Officer by email on 22/5/2025 itself only. Now, however, ink signed original copy of the communication is yet to be received. Therefore, Defence State Officer is examining the same on the basis of email communication, and it is likely to take some time to take decision in this regard. It is important to mention that this process of deliberation and taking decision on deposit of 50% amount is likely to take some more time, as the same involves taking opinion of Law Ministry, approval of the competent authority, and allocation of funds. But in the meanwhile, the period of 3 months granted to deposit 50% of the amount of compensation as ordered by is likely to expire on 12/6, rather 10/6. 11/6 itself it will expire. Now, in view of the above, is a need of extension to take decision either to deposit or prefer SLP before the Honorable Supreme Court against the interim order so and so. It is important to mention that the hearing of the case was fixed on 27/5 and the appeal itself was heard in part on merits before Honorable Justice so and so and was further heard on. On these two dates, on behalf of Government of India, argument was made on the issue of jurisdiction of the reference court at the instance of one so-called power of attorney holder purported to be representing 102 landowners on the strength of a notarized power of attorney, and also on the ground that so-called power of attorney holder has no locus to make the reference on behalf of landowners who were neither aggrieved nor raised any protest before the Deputy Commissioner, and therefore the decree has been obtained by fraud. Now, my lord, in view of this, my lord, we have made a prayer before your lordships to kindly extend the period to deposit, my lord, because it is not very likelihood, my lord, that we get the approval from the higher authorities, and the fund could also come, my lord, to be deposited, my lord, in terms of that, my lords. Therefore, my lord, our prayer is, my lord, that meanwhile, my lords, the 2 months time may be granted further, my lord, for compliance of the order, my lords. And till then, we may be protected, my lords. This is precisely we have submitted, my lords. Now, my lords, in this connection, I would like to invite my lord's attention, my lord, in continuation of my argument which I had made on the issue of jurisdiction before your lordships. Now, your lordship will consider that unless and until we could have got the, my lord, calculation of the amount, it was not possible to take any final decision to for the allocation of funds, my lord, because the funds will have to come to the Defence Ministry from the Ministry of Finance, being a huge amount, my lord. It was beyond the sanction amount, my lord. Therefore, it was necessary, and there has been no delay on our part. We immediately wrote to the DC, my lords, Leparda, for providing us the details, my lord, which has been furnished only on 22/5, my lord. So thereafter, the process is on, my lords. And, my lord, then, my lord, another aspect of the matter, that this order is to be complied by the government, not by any private person, my lords. So far the money is concerned, it is safe. Now, if your lordship founds that the reference court had no jurisdiction and the order suffers from fraud, my lord, then there will be no requirement of that, my lord. Then, my lords, it is not likely to adverse the interest of the party, because the party's interest is safeguarded, my lord, because there is a government guarantee. Now, my lord, in this connection, I just wanted to highlight, my lord, 14 points, my lord, which I have jotted down, which my learned friend will pass on to your lordships, my lord, for your lordship's very kind consideration in this connection also, my lord.
No, you can submit the same after completion of argument of the other side, because on the other day we have concluded.
Your lordship, my lords, definitely, your lordships.
Okay.
Then your lordship, the other side may start his argument, my lord. But my lord, this was just to recapitulate also, my lord.
Okay.
It is nothing new, my lord.
We'll see after hearing their argument.
I take 5 minutes, my lord.
No,
My
not
lord,
now. Not now.
lordships, as your lordship.
Let them complete their argument.
Lordships, let them complete their argument.
Yes,
Great.
Mr. Regarding this IA,
My lord.
anything to submit?
My lord, what I see from my limited understanding of the subject, my lord, is that they of course have a right to seek an appeal against the interim order. They also indicate that yes, our opinion in this regard is sought from the law ministry. Of course, government file moving and processes, it takes time. We understand that, my lord. Then the issue, my lord, is that the learned court, while asking this order of deposit, my lord, the same issues relating to power of attorney, fraud, etc., were argued. These were considered, my lord, in the order of the learned judge when this order for deposit was passed. And this was also passed, my lord, in view of several other decisions of the apex court, which indicate that in land acquisition cases, the deposit is to be made, my lord, like in all other money appeals. And I believe the learned judge at that point of time protected the interest of everybody by saying that though the money is to be deposited, it is not to be released to us. The deposit actually saves further interest, my lord, accumulation of further interest, my lord, on the amount. Now, if on the issue of, my lord, the said decree itself have been obtained by fraud, etc., what is being alleged, my lord, as of now. If that issue is gone into, my lord, and a modification of this earlier order of Justice, I think it's by Justice Thakuria, my lord. So if we go into that aspect, my lord, and if that be the ground for extension, my lord, it amount to a review, my lord, of that particular judgment. Because these aspects were definitely considered, my lord. If your lordship looks, just have a look at the particular order relating to deposit. All these aspects and all relevant decisions in this regard were also placed and argued, my lord. Yes, of course, no doubt.
That's all right, but the other grounds,
The other ground, my lord,
which they have prayed for.
my lord, the other ground is that they say that we have received the calculation from DC just recently. My lord, the calculation is arithmetic, my lord. The mighty union can easily do a calculation. The deputy commissioner is not required. Once a land acquisition award is made, the collector is actually functions officio. He has no role to play except come and participate in reference and appeal proceedings. So he is sending the award and calculating it again, my lord. That is probably not relevant. The union can as well, my lord, calculate of their own, my lord. They have their own officers. They can calculate. That cannot be a ground. But then, yes, I understand that if they want to challenge that order, of course, my lord. If the time is being consumed for that purpose, my lord, they are at liberty. And as of now, there is no such urgency because even though a stay has been granted, my lord, till now we have not initiated any execution proceeding. Execution is yet to be filed. And in the main case, your lordship would see that the appeal, the impugned judgment, my lord, is stayed till disposal of the appeal. Of course, subject to deposit. But then that deposit, my lord, of course, in due course, it would happen, my lord. Or it may not happen also, because if the appeal is heard and finally decided as the learned AG is saying, my lord, then of course the question of deposit would not come. But then to independently touch this particular judgment on this aspect, my lord, as to whether since these points are being urged now, that it was a degree obtained by fraud, if that be so, if that was argued before the learned single judge on the other day also, if she had considered in her discretion, whatever, because deposit is more or less a question of discretion, my lord, because once a decree is passed under Order 41 Rule 6, my lord, as far as stay of execution is concerned, court has a discretion to ask for any deposit. So she had exercised her discretion, and if any modification on that order would come, my lord, it would amount to a review. My humble understanding says so. And as far as I think extension of time is concerned, my lord, there is only one provision in CPC, if your lordship takes up, I think it is section 148. The court actually provides for some, because every situation has some remedy in our law, my lord. Section 148 says, my lord, enlargement of time. Where any period is fixed or granted by the court for doing any act prescribed or allowed by this code, the code may in its discretion from time to time enlarge such period, not exceeding 30 days in total, even though the period originally fixed or granted may have expired. So 148 gives a power of, my lord, extending it for 30 days maximum, my lord.
Okay,
This is the statutory
30 days
provision.
then.
It is a statutory provision is there, my lord. That I have to frankly point out
Okay.
that this provision is there in the code. But then if we touch upon the other aspect that the grounds they are showing, my lord, may, my lord, like if we touch
They
upon
may,
that,
they may raise any other grounds,
definitely,
but
definitely.
only on this point we can consider their prayer.
My lord, what I see is that this deposit is also a question of discretion and enlargement of time is also a question of discretion. This enlargement can happen for 30 days, my lord.
Mm.
And of course, there's an indication that the matter is going to the Supreme Court. My lord, the interim stays
Let
only,
us
my
go to
lord.
the main appeal.
My lord. So I'll leave it to, because it's a question of discretion. 140 is a question of discretion. I will leave it to your lordship.
Yes, yes.
As far as the main appeal is concerned, my lord, the context of the case, my lord, was explained by the appellants, my lord, in a particular manner. I only beg to add to some elements about the context of the case, my lord, so as to understand, my lord, or make my picture clear as to where we stand, my lord, and how we stand in the law, my lord. For them, my lord, it is a question of, my lord, enhanced compensation, monetary repercussion on the exchequer is there. And secondly, they say that it has been, where the money would go, beneficiaries, whether they will be benefited or not, because the authority by which the case has been filed itself, they say, is in cloud. And therefore, the question of, my lord, whether it should be entertained or not is being raised. But then if your lordship comes and steps into the shoes of the landowner, for them, my lord, land is a valuable asset and right. And that is not only protected by the law under the 1894 Act and the 2013 Act now, but then it is also part of Article 300A, lordship knows it very well. And that 300A, my lord, now has been in the recent trend of judgments, my lord, have been interpreted by the Apex Court as being part of basic human right also. So for us, my lord, what happens is that when my land is gone, we would definitely have a right to ask that I should be fairly compensated. Now, that compensation, lordship knows that it cannot be illusory, it has to be actual. That is the trend of law, my lord. And how we were, my lord, hit by this process of acquisition is that, my lord, lordship had probably looked into the aspect that in this particular acquisition, my lord, urgency clause was used. Urgency clause, my lord, is in section 40 here. Now, what is the consequence of urgency clause, my lord, is vital to understand.
You're referring to section
Section 40
of
of the 2013 Act, my lord. Earlier, it was section 17. Section 40, my lord. Earlier, it was section 17. Only a slight difference in section 40 has come because in the earlier Act of 1894, my lord, the purpose for which urgency clause could be used, my lord, was not very well defined. So when this 13 Act was being drafted, my lord, it was found that earlier there was a lot of misuse of urgency clause, and for non-important and even for private companies, my lord, land was acquired under urgency clause. Now this purpose has been therefore restricted, that it is only for urgent government of India projects, like defense projects, road projects. Only for this, the urgency clause can be used. One aspect of urgency clause is that, my lord, you can take over possession immediately after even before the award, the possession can be taken over, so that the work as far as the land development and use is concerned for the user department, it can proceed smoothly. Secondly, my lord, what we are hit by, my lord, is that when urgency clause is used, my lord, if your lordship looks at subsection 4, in case of any land to which, in opinion of the appropriate government, provisions of subsection 1, subsection 2, or subsection 3 are applicable, the appropriate government may direct that all or of the provisions of chapter 2 to 6 shall not apply, and if it so directs, a declaration may be made under section 19 in respect of the land at the time, any time after the date of publication and preliminary notification under subsection 1 of section 11. So when urgency clause is used, my lord, what are these chapters? These chapters are, my lord, eliminated. Chapter 2 is, my lord, social impact assessment, because it delays the project, so therefore it is exempted. Secondly, my lord, chapter 3 is food and food security safeguard. Then chapter 5 and chapter 6 is what we as landowners, my lord, suffer. That rehabilitation and resettlement is also exempted, my lord. So when a land is taken over under urgency clause, the landowners don't get rehabilitation under the 2013 Act. Otherwise, if my land is taken, I not only get compensation, but then the government has to give me a rehabilitation package. So a suitable land somewhere else also has to be offered alongside the compensation. So that is dispensed with. So where we are left is, when the urgency clause is invoked, is that, my lord, when the compensation is given to us, my lord, what we have to do is that, therefore, we have to use that compensation to procure other equivalent suitable plots of land. So therefore, the compensation, the necessity of the compensation to be just and fair, my lord, is very vital when urgency clause is there. So more detailed scrutiny into that aspect is required, my lord. So that is what I wanted to highlight, my lord. Then another aspect as to the background of the matter was that that was placed was that, my lord, it has been argued that people were willing to spare their land, and therefore only by calculating the estimated cost that had come for the acquisition, government had gone forward with the acquisition, and otherwise probably as other plot of land or other suitable land would have been taken over by the government. But then defense land acquisition, my lord, is, however, slightly different, my lord, as I understand from my experience. In fact, in cross-examination of the DEO, Defense Estate Officer, I had put him pointed question on this regard, that you have a policy as far as acquisition is concerned of 1992. That 1992 policy says, my lord, that firstly you identify the land, then approval in principle is taken from the Defense Ministry as far as the requirement of that particular land. And in this case, my lord, from the cross of DO, I will read out later, my lord, he had clearly said that in 2010, this AIP was procured in this particular case. So government had already taken a decision to acquire the land in 2010. So as landowners, where we stand then at that point of time, I know that my land is going away. I cannot probably, tomorrow or the other day, acquisition process will start. There's no point in developing the land or maybe putting it to some other use also, though formal acquisition was yet to start. Thereafter, my lord, there were procedures and delays in procedure, whatever. ultimately from 2020 onwards, they say that we started this acquisition process. So they start the acquisition process, and acquisition process, as I understand, my lord, it starts from the date of preliminary notification. Lordship is also quite aware of that. Before that, it can be any discussion or any decision that is taking place. It is basically an internal correspondence which has no relevance as far as the acquisition of the land is concerned. So the crucial and cutoff date here in this particular case is the date of section 11 notification, which is 23rd of March, 2023. Why I'm pointing out, my lord, is that some documents have been filed by the respondents which say that there was correspondence going on regarding acquisition of the land, and people had signed willingness, etc. But then what we urged before the learned trial court is that these were processes before the acquisition started as per the due process of law. Now, I don't have any right prior to the due process being commenced of objecting to the acquisition. My right only comes as per the statute once you put the notification. After notification, I have a right to object under section 15, but then since urgency clause is used, section 15 is gone. Then only remedy is after award, we have to seek a reference. So that seems to be the scheme of the act, my lord. Then I would like to point out, my lord, as far as the question of these documents are concerned as to what had happened, my lord, before the acquisition itself started through a due process of law. Lordship was probably pointed out some documents, my lord, as Lordship could see page 332 was pointed out.
Yes. Willingness.
Willingness and no change of mind certificate. This is of 19/3/2020. Way before, my lord, the land acquisition process started, actually, as per the provisions of law. Now, at that point of time, Lordship, as I had pointed out, in 2010 onwards, you are intending to acquire this particular land. And in between, you are doing correspondences, which is not contemplated under the statute, but then it is contemplated maybe as per your own internal requirements of like making an assessment of the land. But then you had already identified the land, and thereafter you intended to acquire it, and then you did some internal procedures as far as the sanction that is required for acquisition is to be obtained. You had done some procedures. I have no right to object to those procedures because these are not procedures prescribed under any statute. So that is why I pointed out before the trial court that though these documents are there, we are not denying it. But then whether it has any relevance as far as the main issue that is brought out in the reference is concerned. This willingness, my lord, was again, your lordship would know that it is signed by only 4 persons, not the entire batch of landowners. And then there is another document, my lord, at page 338.
Yes.
Page 338, my lord. This is, my lord, part of actually a annexer of a earlier letter, my lord, so as to get the date, my lord. I think this sheet is actually part of this page 330, my lord. Revised cost sheet
Page number
30, 16 March 2023. 16 March 2023. Revised cost sheet for acquisition of land measuring 537 acres regarding. So then these papers are thereafter annexed, my lord. That's part of this particular letter. So this is also, I had actually pointed out a question in cross also in this aspect, that whether these correspondences are before issuance of the section 11 notification or after that. So the record clearly shows that these are actually prior to the actual acquisition process being commenced. So these documents, my lord, would have little relevance as far as, my lord, determination of compensation is concerned, because these are not done under any prescribed procedure of law. Law says, my lord, how acquisition takes place is that you notify a land to be acquired. Thereafter, my lord, objections are heard. Thereafter, award is made. The award is also made by the collector by assessing the market value prevailing on the date on which the notification under section 11 is made. So on 23rd March 2023, what was the market value prevailing? Award is to be made. This exercise, the legal exercise, is to be carried out after, my lord, the notification happens. And it seems, my lord, if we lay too much of emphasis on these documents, it would amount that the award was passed even before the notification was made. That cannot be. How can there be an award and assessment of compensation even before the notification under section 11 is made?
So you are referring to this preliminary notification?
No, my lord, I'm not coming to that. Preliminary notification is thereafter. After all these things have happened, preliminary notification comes on 23rd of March 2023. So all the correspondences regarding acquisition of the land made before the date of preliminary notification has no relevance in a reference, because reference will decide, my lord, only the market value after notification, because that is when the process of acquisition as per law is set in motion. Prior to that, my lord, these are all exchanges of correspondence, internal correspondences of the department, which will not have any binding value on anybody, my lord. Then, my lord would also see that the AIP, my lord, was done in 2010 of this matter. The valuation then initially that was taken in 2010 was 150 rupees per square meter. Now the acquisition did not take place for a long time, for 10 years, more than 10 years. Now, when the acquisition finally takes place after 10 years or 12 years, my lord, we are again being given the same rate of 150 rupees. As if, my lord, nothing, the price of anything has not escalated. So that was the primary difference of everybody, my lord. That you had in lordship take a situation that had we been paid, my lord, after the AIP, my lord, if acquisition was completed in 2011-12, if we had got 150 rupees, then, my lord, probably we could have used that money to get other suitable plots of land, because that was valuable at that point of time. So here is a case where in 2010 also we would have got, my lord, 150 rupees, and in 2024 also we are getting 150 rupees without any escalation. There are many reasons as to why this was required to be done and why it was not done also. That as far as the arguments, as far as the rate is concerned, my lord, I will come to. But then my emphasis, my lord, is on the fact that on the case of rates, lordship sees that prima facie, it is unbelievable that something which was costing 150 rupees in 2010 as valuable as land, in 2024, there has been no escalation. So we, of course, had to justify that through evidence and other judicial precedents. We had done so. So on that part of the award, my lord, I believe we stand on a good footing. So therefore, my lord, we are being probably assailed, my lord, from the other side, saying that your reference itself was not valid. Now, I come to this aspect, my lord, that as far as the reference is concerned, my lord, a submission has been made. In fact, in the written statement, if your lordship says, the written statement of the Ministry of Defense, my lord. So, volume of the-
Page number?
My lord, I'm coming to it.
283, my lords. Annexure 4.
283, it starts from there, my lord. It starts from 283. I was trying to, my lord, specifically point out that one issue that has been raised is that section 64 application in itself was not properly placed on record, my lord. In fact, that issue was, my lord, argued and urged, my lord, in the reference code also. And the officers of the Defense Ministry, my lord, present there in the court, I had specifically shown them the court record that the collector had received that application on, if your lordship also has a look into the LCR, lordship would see that it is part of the record. The collector had received it and thereafter he has to give a statement under section 65, sending it to the authority. So that procedure was complied, my lord. So it's not a case where proper reference itself was not made, my lord. So the LCR, that aspect would be quite clear, that application under section 64 was filed and that application need not be actually addressed to the Ministry of Defense or the requiring body, because the statute says that, my lord, that application has to be addressed only to the collector. So we had addressed it to the collector saying that these are our grievances. And thereafter the collector, my lord, had given his statement, my lord, under section 65 as to on what basis he had calculated the award. And with that statement, my lord, he had forwarded it to the court. The court thereafter registered a case. Now, because the word jurisdiction has been brought in on a number of occasions, my lord, I would invite your lordship to have a look at section 67 of the Right to Fair Compensation and Transparency Act 2013. What I intend to, my lord, highlight is that what is the scope and authority of a reference court, my lord? Because a reference court, my lord, is a special tribunal. Though it enjoys a power of a civil court, it is a special court created by the statute to decide only particular things. That is what I have understood, my lord, by reading of section 67. Section 67 says that restriction on scope of proceedings. So it starts with a negative covenant, my lord. The scope of inquiry in every such proceedings shall be restricted to a consideration of the interest of the persons affected by the objection.
Yes.
Now, what is this objection, my lord? The word objection again has to be read with section 64.
Hmm.
64 says that any person who has not accepted the award may by written application to the collector require that the matter be referred to the collector for determination of the authority as the case may be, whether his objection be to the measurement of land, amount of compensation, the persons to whom it is payable, the right of rehabilitation and resettlement under chapter 5 and 6, or apportionment of compensation among the persons interested. So there are 5 listed. Earlier it was 4, my lord. This was, I think, earlier section 18 also had a similar provision. But then this rehabilitation aspect was not there. So now there are enlisted 5 things that the reference court has a jurisdiction to decide on. Now, therefore, what my understanding goes, my lord, of the different judgments in this regard is that when a reference comes to the court, the only thing that the reference court has to see is that whether the compensation paid was sufficient, and if not, my lord, what would be the correct compensation. So in this regard, I'll just place a few judgments, my lord. My lord, firstly, 2003, 5 SCC, 561. I'll lead your lordship to para 7. It is well established that reference court gets jurisdiction only if the matter is referred to it under section 18 or 30. Now it is 64 of the Act of the Land Acquisition Officer, and that of the civil court has to go to the jurisdiction and authority only to decide the objections referred to it. So objections referred to it is on the adequacy of the compensation, my lord. The reference court cannot widen the scope of its jurisdiction or decide matters which are not referred to it. This question was considered by various judicial authorities, and one of the earliest decisions reported in this point is Prathamanath Malik Bahadur versus Secretary of State. This is a case where claimant sought reference under section 18 of the Act. In the application filed by the claimant, he raised objection only regarding the valuation of the land. The claimant did not dispute the measurement of the land given in the award. Before the reference court, the claimant raised objection regarding measurement of the land and sought for fresh measurement. This was refused, and the claimant applied to the High Court for revision of this order without success. Again, in appeal, the claimant raised the same objection regarding measurement, and the High Court rejected it. The Judicial Committee of the Privy Council had thus. Their lordships have no doubt that jurisdiction of courts under this Act is a special one, and it is strictly limited by terms of these sections. It only arises when a specific objection has been taken to the collector's award, and it is confined to a consideration of that objection. Once, therefore, it is ascertained that the only objection taken is to the amount of compensation, that alone is the matter referred, and the court has no power to determine or consider anything beyond it. In our case, Muhammad Hasinuddin versus State of Maharashtra, it has been observed, para 25, that a tribunal of limited jurisdiction is not only entitled but bound to determine whether the matter in which it is asked to exercise jurisdiction comes within the limits of its special jurisdiction, and whether jurisdiction of such tribunal is dependent on the existence of certain facts or circumstances. It is obvious duty to see that these facts and circumstances exist to invest with its jurisdiction, and where a tribunal derives its jurisdiction from the statute that creates it, and also defines the conditions under which the tribunals can function. It goes without saying that before the tribunal assumes jurisdiction in the matter, it must be satisfied that the conditions required for acquiring cessation of that matter has been taken, my lord. Similar observation, my lord, in para 9 also. Earlier, this restriction, my lord, of section 67 was in section 21 of the 1894 Act. Para 9, the quoted part I am reading, my lord, that the matter goes to the court only upon a reference is made by the collector. It is only after such reference is made that the court is empowered to determine the objections made by the claimant to the award. Section 21 restricts the scope of proceeding before the court to consideration of the contentions of the persons affected by the objections. A similar view, my lord, has been taken in thereafter, my lord, in 2006, 13 SCC 754. 2006, 13 SCC 754. Para 11 onwards, my lord. In fact, this Prayag's case is quoted here, my lord. Para 11 onwards, my lord. Again, my lord, Prathama Mallik is quoted. Prayag is quoted, my lord.
Please break up you have referred.
My lord, para 11, 12, 13 and 14.
11, 13.
And again, my lord, in Shamali Das versus
My lord,
Ilaso.
if your lordship permits me, my lord. My lord, it appears that my learned friend is completely digressing the issue. My lord, these issues I have not at all touched, my lord. I had touched only the question of jurisdiction. I have not touched about rate. I did not touch about the multiplication factor. I had only touched on his authority to approach and file a reference case, particularly in the context of the fact that none of the landowners had authorized him, and it is all fraudulent power of attorney. But my learned friend, I mean, I was listening, my lord, his arguments, and I see that he is completely digressing. He is just avoiding those argument. He is not replying, and he is coming on the rate, my lord. And he is referring to the judgments on the rate, my lord. I did not touch this issue. I was only on the jurisdiction issue. First, he should have addressed and assisted your lordships on that issue, my lord, because on those issues I have not yet, because I am on the jurisdiction itself. Even before this this honorable court, my lord, none of the landowner has come. It is on the same power of attorney, on the strength of that, my lord, this person is here, my lord. So on that issue, he should have addressed, my lord. But instead of that, he is addressing on the rate and about the enhancement in the rate, etc. So that only that to that effect is my objection before your lordships about the argument of my learned friend. He should meet those arguments which I have raised, my lord. And not that, because I have not raised these arguments on the issue of rate, etc. And I have not even cited one judgment, because I was on pure fact, my lord, that how the things have approached, my lord, and how he has gone in reference court, my lord. I have not even challenged that the DC has...
Maybe he has only initiated his argument. Let him complete. We'll see.
As your lordship, as your...
I will give an opportunity to you to reply to his submission.
Lordship.
Okay.
Because, my lord, we all have different styles of argument, my lord. We all have, my lord, we are entitled to have different styles of argument.
Yes,
my lord.
yes.
So we can,
My objection was that at the very threshold, he, on the strength of power of attorney, has no right to approach the reference court, my lord.
Okay, that's all right. Definitely, he will address that issue.
Lordship, grateful.
Yes.
My lord.
Yes.
So I am citing, my lord, this judgments because these are relevant, my lord. That question is that what jurisdiction and what powers, my lord, the reference court can exercise. So to understand that, my lord, whether a issue as raised by them before the reference court is a issue, an objection that a reference court can decide is also to be seen, my lord. Therefore, I am, my lord, pointing out this aspect. That thereafter also in Shamali Das, my lord, in Ilas Vadori 2006, 12 SCC, 300. Para 19. The act is a complete code by itself. It provides for remedies not only to those whose lands have been acquired, but also to those who claim the awarded amount or any apportionment thereof. A land acquisition judge derives his jurisdiction from the order of reference. It is bound thereby. His jurisdiction is to determine adequacy or otherwise of the amount of compensation paid under the award made by the collector. It is not within his domain to entertain any application of pro inter so or nature thereof. So other issues and claims cannot be brought in, my lord. Of course, this can be hesitated, my lord. There are so many other forums. Say, I think at one point of time, the learned trial judge, my lord, also refers to, my lord, section 201 and 202 of the Contract Act as far as power of attorney and agencies are concerned, my lord. There are different modes of, my lord, looking and into addressing this issue. So how deep actually we can go into this issue as to whether reference court can go into this particular issue, because it's a special tribunal, my lord. Because his jurisdiction is on the raid aspect only. Therefore, my lord, this issue has to be examined a little bit more deeply, my lord. Recently, my lord, our own High Court also has rendered a similar judgment, my lord. It's Justice Borua. Here is a case where, my lord, the question of limitation was raised, my lord. That it was filed beyond limitation, and whether the reference court therefore can go into that aspect. The court said it's no, my lord. The para 18 onwards, I'm reading, my lord. Page 17, para 18.
Yes.
Now, therefore, the question arises is that when a learned reference court gets the jurisdiction to decide the reference on being made by the collector, can the learned reference court rule on its own jurisdiction, or in other words, entertain a challenge to the maintainability of the reference proceeding? Then Prathama Malik is quoted, my lord. That is already, my lord, indicated in the different judgments. Then Prayag Upanivesh is also, my lord, quoted, which I had also referred to, my lord. Then Shamali Das is also quoted, my lord. That also I had independently placed, and I had placed another judgment of similar tenor. Para 22, my lord, it says that from the above analysis, it can be called out that the order of reference made to the court by the collector confers jurisdiction upon reference court to decide the objections in respect to which reference has been made. The reference court, unlike an arbitral tribunal under the Arbitration and Conciliation Act 1996, have not been conferred with the power to rule its own jurisdiction. Arbitration Conciliation Act, my lord, section 16, the tribunal can rule its own jurisdiction. And then no similar provision is there in the Land Acquisition Act, my lord. Have been conferred with the power to rule its own jurisdiction, or in other words, entertain a challenge to the maintainability of reference. Rather, the Act of 1894 constricts the jurisdiction to the learned reference court to decide only on the consideration of the interest of the persons affected by the objection, and nothing more, as would be seen from section 21 of the Act of 1894. 21, my lord, I'm again pointing out, is the earlier provision in the 1894 Act. Now, the exact words are repeated in section 67 of the 2013 Act. Therefore, jurisdiction of a learned reference court, though a civil court, is confined to decide within the four corners of the authority conferred by the Act of 1894, that is, answer the reference so made by the collector and pass the award in terms of section 26 of the Act of 1894. In the instant reference proceeding, the objection referred to the learned reference court by the district collector was as regards insufficiency of compensation. The learned reference court therefore was obligated to answer the reference as to whether such amount adjust as compensation is just, fair and reasonable as per the 1894 Act, and if not, what would be the just and fair compensation or reasonable compensation. So if we go by section 67 and earlier 21, my lord, special tribunal, my lord, though we may raise 101 issues, my lord, a special tribunal is not the forum where these issues can be raised. And even if it is raised, my lord, the tribunal would not have any jurisdiction to rule on those issues, because the special tribunal is only given a power to, my lord, find out whether the rate given by the collector is correct or not, and if not, what is the correct rate. That is the only jurisdiction he has. And in that process, yes, he has the powers under the Code of Civil Procedure to summon witnesses, to take evidence, and come to a finding as to whether the rate offered by the collector was correct, or if not, what would be a reasonable rate. So that is the only jurisdiction he can exercise. The question of maintainability as such, my lord, I would not be suggesting as to what would be the other alternative remedies, my lord. But then the reference court is definitely, my lord, from the context of what we see, is not a court where
when
these
a
issues can be
definite-
gone.
No. When a definite plea is taken in the written statement by the respondent, whether the court
My-
is not bound to answer the same, to
My
deal
lord.
with the same.
My lord, therefore, an issue was framed. Therefore, still an issue was framed as far as maintainability is concerned. Though, from what we understand from a broader study of the law, is that these are issues of, my lord, these are not the core issues which basically the reference court has to answer. But then still, since a plea was taken, my lord, this was addressed. This was addressed, my lord. And your lordship has seen probably issue number 1 was basically on maintainability, and it was split up in 3 parts as far as limitation, as far as, my lord, the power of attorney is concerned, and as far as, my lord, the right to seek reference is concerned. That was split up in 3 parts, and it was answered accordingly, my lord. The correctness of that judgment, of course, your lordship would scrutinize. But then it is not a case where it was not addressed at all, my lord. And it has to be addressed, my lord, in context of, my lord, what was argued and pleaded and placed before the reference court. Now, as I come, my lord, to this issue of power of attorney, my lord, lordship had on the other date had a look at the Power of Attorney Act, probably. This act, my lord, does not specify, as your lordship had seen, that any manner or mode in which a power of attorney is to be executed. So that is primarily for the reason that, my lord, the power of attorney is a species of contract of agency. And as far as contract of agency is concerned, my lord, the detailed provisions are there in the Indian Contract Act. Indian Contract Act. Chapter 10, my lord.
Yes.
182, my lord, agent and principal are defined. So there are 2 parties only in a contract of agency. One is an agent and one is the principal, my lord. So in between them, like all other contracts, which is inter-party, there is a privity as to what I am asking him to do or what he will do for me. There is an absolute privity in that particular contract. Unless and until the grantor or the donee of the power of attorney himself comes and says that I have not given you this authority, or you have acted beyond the authority that I have given, or you have breached the conditions of the agency that I have given, or I intend to now revoke it. So the principal or the donee of the power of attorney is the prime person, my lord, who has to, or who has a right basically to say that whether he has given this power of attorney or not. Now, thereafter different provisions are there, my lord. But then I would also, since we are reading from the Contract Act, my lord, I would also again invite your lordship to look at 196, section 196. Now this contemplates a situation, say somebody acts as my agent,
Yes.
and tomorrow somebody questions that whether this particular agent is having power to act or not. So under the law, then under 196, the donee can come and again ratify these acts. He can come and say that, yes, no, my authority given to him is correct. So this is what 196 says, where acts are done by one person on behalf of another. So the element of ratification is there. This again, my lord, has to be read with this doctrine of what we call relation back, my lord. Ratification is related to relation back doctrine, which says that if I today ratify my act of having done something earlier, my date of ratification, despite being today, it will relate back to the date of the original date. So if I ratify something that had happened in 2023, even though I am ratifying it in 2025, that ratification would cure everything. I will place decisions in this regard also, my lord. Then, how can a termination of agency take place, my lord? The agency can be actually terminated only by principal. So the number of cases, my lord, I've tried to find out is that all cases where power of attorney is being challenged is where the principal comes and says that you have sold my land by forging my power of attorney. So I revoke it, and the transaction that has happened subsequently. So the principal has to come and say that I have not given you any authority. Why are you acting on my behalf? I am terminating your agency. I am revoking everything. So termination of agency, my lord, 201 says that an agency is terminated by the principal his authority or by the agent renouncing his business of the agency. The person who is acting as an agent, he can also renounce. He can say that, oh, I elect not to be your agent anymore. Or by the business of agency being completed, or by the principal or agent dying or becoming unsound of mind, or by principal being adjudicated and insolvent under the provisions of the Act from the time being enforced. Then 202 says that where there is an agent, where the agent himself has an interest in the property which forms the subject matter of the agency cannot, in absence of an express contract, be terminated to the prejudice of such interest. So the modes thereafter, my lord, as to how a power of attorney is to be impounded, challenged, revoked, cancelled, is there in the Contract Act. Now, as far as the execution of the document itself is concerned, my lord, we had shown that it was a notarized document. Notarized. Lordship had on the other day read already a section 8 from the notary the notary may do all or the following things by virtue of his office, namely verify, authenticate, and certify or attest execution of any instrument. Then promissory note, hundis, commission, recording of evidence, etc. are probably not relevant for our part, my lord. And there are rules also, my lord, in the notary's rule, 1956. So it says that the notary has to maintain registers, etc., books and volumes of his recording of such notarized documents that he does. So these rules, I'm not repeating again, my lord, these are all already pointed out. But then nowhere in these rules, my lord, we could find a specific requirement that, my lord, a particular manner is prescribed somewhere as to how the attestation or notarization take place. The very meaning of what attestation, my lord, here is that he certifies that yes, this person has executed this particular document. Now, therefore, what the trial court had also looked into as far as the power of attorney is concerned, my lord, section 85 was probably referred to of the Indian Evidence Act. '85, and since I think the evidence recording took place, my lord, in this matter after the Adhinium of 2023 had come in. So I will point out the in perimeter provisions also, my lord. Earlier, there was a provision in 85 that court shall presume that every document purporting to be a power of attorney and to have been executed before and authenticated by a notary public or any court, judge, magistrate, Indian consul, vice consul, or representative of the central government was so executed and authenticated. So when I come with a power of attorney, I come with an initial presumption under the law that it is genuine. The court will not start from the premises that you will be asked to prove whether it is genuine or not. It will, because I come with a presumption, my lord, that it is genuine. Now, Lordship is aware that it can be rebutted. These are, of course, any presumptions would be in law. Any presumption in law is rebuttable. And then how that rebuttal should take place, I would come to that, my lord. In section 84 of the Act of 2023, now the Saksha Adhiniam, the similar provision is repeated, my lord. The presumption as to power of attorney, the same provision is there. Now, as a plaintiff or a petitioner in that reference proceeding, what was required to prove initially, my lord? Your lordship would look at the provision of section 91 earlier. Now it has, my lord, become section 94. Says when terms of a contract, power of attorney is
Act.
My lord, I'm referring to both the provisions, my lord, of 1870 also and also 2023. In 2023, my lord, section 91, as it stood earlier, has become section 94. Now, I would read only 94 then, my lord, because the evidence was recorded after coming of this particular act in force, my lord. 94 says that when the terms of a contract or of a grant or any other disposition of property have been reduced to form of a document, and in all cases in which any matter is required by law to be reduced to the form of a document, No evidence shall be given in proof of the terms of such contract, grant, or other disposition of property or such matter except the document itself or secondary evidence of its content, in which secondary evidence is admissible under the provisions herein above contained by law. So when I produce a document, my lord, before a court, all I require to do is that I need to place the particular contract, and my initial burden of that document being in existence is fulfilled by production of the same. So the power of attorney is the first document that we had exhibited. Now, as I say that, my lord, this presumption, my lord, is a rebuttable presumption. So what kind of a rebuttal, my lord, did come, my lord, from their side is what I would like to highlight, my lord. Evidence statement. Evidence to allow. Oh. But she would come to page 284. Something wrong with the PC, my lord, probably. Is it working? Can you check? The video conference?
This is not coming here.
Okay. So it's not actually showing here actually. So I was wondering if the video disconnected. It's saying Zoom is not responding. Maybe only with this machine, maybe. Is something wrong. Well, para 3 onwards. Before going into the merit of the case, it is very much imperative to analyze whether applicant Dagli Riba is legally authorized to file the petition claiming such exorbitant compensation on behalf of 102 ex-landowners merely on the basis of a notarized power of attorney holder. Now, Dagli Riba is not the only applicant, my lord. He had only signed on behalf of everybody. Applicant is all the persons, my lord, who are there. As Dagli Riba, my lord, he has only signed, my lord, the petition saying that he is an attorney holder. But then applicants are everybody, my lord, all the landowners who are named in the award, my lord, and in the Section 11 notification. Section 11 is more particularly important here because that is the vital date on which, my lord, our right to claim the compensation as per market rate prevailing there comes. So he had, my lord, signed it on behalf of, he's not the only applicant. The reference application, if your lordship looks, that everybody is the applicant. But then the pleadings are signed by him saying that I'm the attorney holder. Position. Respondents, that is Union of India, is relying upon provisions of Registration Act 1908 for analyzing the legal veracity of power of attorney submitted by the applicants. The preamble to the Act says that Act to consolidate the enactments relating to registration of the documents. The definition of immovable property is mentioned in the Act as follows. Immovable property includes land, buildings, hereditary allowance, right to way, lights, ferries, fisheries, or any other benefits to arise out of land and things attached to art or permanently fastened
As far as our law is concerned, we are going to action. There are certain documents which are research on the compulsory basis, which is not research, that document cannot be created to be valid. And there are issues where we can have optional legislation. Optional legislation method is runs into compulsory. That can now have the option of doing it. And the documents that have to be registered compulsorily. Mentioned in section 17, the relevant documents can be registered with the purpose to which they relate to situated in a district in which they have executed and after that date and which after 1594 that is when they state not that the district not that 1571 and district not that 1877 and this such has been in the state. Two is Miller instruments are used as in the level data. We shall use the property data that which is to be registered in a compulsory. Again, and coming to the just another thing that comes to my mind is that the question of witnessing a document within the that has in the contract there is many requirements in the statute of witnessing a document. So that's why it is signing a contract and there is interactive agreement is one of that has a contract. Witnessing of a contract is not required. But then there are certain exceptions of document that are mentioned in question so in the
if we are allocated has to be registered. And if it is to be registered, my lord, then the question of attaching two witnesses is also necessary. Similarly, if I make a
My lord, under the Indian Succession Act, the registration is compulsory and the witnessing of the same is also compulsory. So there are certain documents, my lord, which are to be attested and witnessed as per provisions of law. And there are some which are not required, my lord. In fact, that aspect, my lord, if I remember, my lord, has been dealt with in the 69th report of the Law Commission, my lord. That entire aspect of, my lord, what are to be registered and what are to be not and what are to be attached and what are not to be attached is already discussed, my lord, and the law is settled. I will place decisions in this regard that if the statute does not mandate that a document is to be witnessed by somebody, then such document is not required to be witnessed at all. And even if it is not witnessed, it still remains a valid document. So my leg of argument would be that in the Power of Attorney Act or in the Contract Act, my lord, there is no requirement of power of attorney being witnessed by somebody. But yes, the question is that if I opt for, my lord, optional registration, at the time of registration, my lord, yes, the people have to identify me and their seal and biometrics and everything is taken these days, my lord. That is when I present it for registration. But then since registration is also not compulsory, my lord, I have an option of doing things on the basis of an authorized power of attorney itself And more particularly when the persons who have given me the power of attorney has not questioned my authority at all. Then B is, my lord, non-testamentary instruments which purport to operate or create, declare, assign, limit, extinguish, whether in present or future, any right, title, interest, vested or contingent of the value of 100 rupees upwards, or in immovable property. Now, they had highlighted this definition of immovable property, my lord, in their WS. But then the context of acquisition is totally different. I think the learned trial judge has also touched upon that issue. Acquisition, my lord, is a power exercise under a specific law by what is known as eminent domain. The government, therefore, gets back its right over the land, because all land, my lord, the eminent domain concept says that all land is actually vested in the government. All we get is pattas and settlements to use it. Absolute right of property is not there. But then there is a constitutional safeguard that when government reclaims the land from you, you have to be given compensation. Subject to death rider, my lord. Otherwise, what I was saying is that there is nothing, my lord, preventing the government from acquiring a particular land. Acquisition would take place, and the moment the declaration, in fact, is made, it is section 19 and earlier, my lord, section 6 itself very clearly says that government had intended, therefore, to vest its title over this particular land. And on the acquisition being completed, the title is already totally vested with the government. There is no transfer of property in terms of, my lord, what we understand in the Transfer of Property Act. In the Transfer of Property Act, I sell the land to somebody. In that case, my lord, yes, the selling, the purpose of selling and vesting of immovable property, a registration of any deed or act in this regard would be required. So if I act as a power of attorney of somebody, for me to sell that particular plot of land, my lord, the registration of that deed might be necessary. Not only that, section 32 and 33 again says that there is a manner also in which it is to be done. If that is not done, the transaction in the immovable property would fail. But then here is a case where land acquisition took place, and by operation of law, the title went to the central government. So there is no such transaction in immovable property which would fall, my lord, under 17B to make the power of attorney registrable in a compulsory manner. Then C is non-testamentary instruments which acknowledge the receipt of payment of any consideration, and so and so, so and so, so and so. Now, the one important aspect of the power of attorney, again, my lord, is here that this power of attorney, the trial court also says so. This is only for the purpose of instituting litigation, that this, because lordship knows that under order 1, rule 1 CPC, my lord, all persons who are aggrieved by a same cause of action, instead of filing 102 different cases, they can come together in a single suit and seek redressal of their grievances. And for that purpose, instead of, my lord, everybody coming to court individually, they had collectively come and authorize a particular person to sign on their behalf. It's also not a case in some power of attorneys, lordship, I find, which they also probably are suspecting a lot. They are trying to repeatedly say that this power of attorney holder is a dangerous man. He will fraud, he will manufacture bank accounts of everybody and siphon away all the money if at all any enhancement is to be paid. My lord, this is a case where the power of attorney, if your lordship reads, except for the acts of filing litigation and making affidavits, appointing advocates, no power to receive compensation or receive any money has been given to the power of attorney holder. So it is not, it cannot be a case that by using this, tomorrow if I get something, the power of attorney holder can siphon off the money. In fact, my lord, I had seen that land acquisition compensation these days are paid through RTGS direct to the beneficiary's account. Nobody has any role to play in between. And that kind of a fraud, if it is to happen, my lord, it will happen subsequently. Therefore, my lord, what I had filed a IA application also today on this aspect, that since you say that he is a dangerous man and he's going to siphon off all the money, we want to show that let the collector's record in this regard be placed as that whether all beneficiaries have been paid in their verified accounts. Because if today my awarded amount has come in a verified account, tomorrow if any enhancement comes to me, also will go in the same verified account. It will not go to any individual account somewhere. So that record, my lord, we have called for, we have filed a separate IA for that, my lord. It's under provisions of Order 27. Sorry, Order 41, Rule 27B, my lord, for production of documents which might be vital at the time of appeal for appreciation of the appeal and for coming to a fair conclusion, my lord. That your lordship would consider separately. So what I was pointing out, my lord, is that section 17 does not, my lord, anywhere mention anything about a power of attorney being required to be registered. So we follow, my lord, the Taylor versus Taylor principle, my lord. If the law prescribes it to be done in a particular manner, it has to be done in that manner. If the law does not prescribe it, I am not obligated to, my lord, follow something which is not written in law. And notarized power of attorney, your lordship has seen that the Evidence Act clearly gives a court right to presume that it is correct. So it will proceed on that presumption unless and until that presumption is rebutted. I will come to that, my lord. Again, if we come to section 18, documents of which the registration is optional. These are instruments other than gifts and wills, which so and so, so and so, so and so. In fact, lastly only, all other documents not required by section 17 to be registered. 18F, my lord. So 17 gives you a list of documents which are to be registered. 18F says that all other documents which are not mentioned in specifically section 17 are not required to be registered. Now, my lord, let us come to section 32 and 33, which have been also ours then quoted, my lord, in the written statement. (32), my lord, says persons to present documents for registration, except in cases mentioned in section 31, 88, and 89. Every document to be registered under this act, whether such registration be compulsory or optional, shall be presented at the proper registration office. So if I take a document which is optionally to be registered, then I have to follow a particular procedure, even though it's optional, my lord. It has to be by some person executing or claiming under the same, or in case of a copy of a degree holder claiming to be under the decree or order by a representative or assign of such person, or by agent of such person, a representative or assign duly authorized by power of attorney, executed and authenticated in manner hereinafter provided. Then 33, my lord, says power of attorney recognizable for the purpose of section 32. For the purpose of 32, again, also if a power of attorney holder comes for registration, that is also recognized. For the purpose of section 32, the following power of attorneys alone can be recognized. If the principal at the time of executing the power of attorney resides in any part of India in which this act for the time being is in force, a power of attorney executed before or authenticated by registrar or sub-registrar within whose district or sub-district the principal resides. So when I take a particular document for registration as a power of attorney holder of somebody, that document may be compulsorily registrable or optional. Then, of course, the power of attorney also has to be registered. Only a registered power of attorney holder can present the document for behalf of his principal for registration. So this is a different case altogether. This is a case where, my lord, I as a power of attorney holder have to take something for registration, and for that registration to be accepted, my lord, my attorney itself should be registered. But then in our case, it's a document, the power of attorney itself is not compulsorily to be registered. I have not taken it to a registration office for registration because it's optional. I am neither creating any other instrument which is required to be registered by using this particular power of attorney. So therefore, the registration of my power of attorney is not necessary. So this aspect, my lord, I think has been dealt with in the judgment of the trial court. I will indicate, my lord. Come to the issues straight away, my lord.
Page number?
Page 91, my lord, of the judgment of the reference court.
Yes.
My lord. I'm reading para 52 at page 93. Section 32 and 33 of the Indian Registration Act is part of chapter 5 of Indian Registration Act, which is relating to manner of presenting a document for registration. As per section 32C, document can be presented for registration by the power of attorney holder. Section 33 speaks about the power of attorney holder who can present document for registration under 32C. The stand of the respondent in this regard is erroneous because 32 and 33 of the Registration Act does not speak about the registration of power of attorney itself, but registration of documents presented by power of attorney holder. For instance, when the power of attorney holder is empowered to sell a land, he presents the sale deed for the registration. The provisions of 32 and 33 are placed into operation. In the present case, the attorney has been given only to the extent of pursuing judicial remedies to get compensation. Exhibit 1, power of attorney, does not extinguish any right of the executors, neither does it convey any other right over immovable property of the executors. The right over immovable property of the executors is already extinguished by the process of land acquisition, and they already stand divested from their title and ownership. The claim made in the reference is only for determination of appropriate compensation. He comes to the core issue again, my lord, because that is what, my lord, as I had indicated, is the actual jurisdiction of the reference court. Then it says that in this regard, DW1 was cross-examined by respondent number 2 and 5. Now, DW1 is the deputy commissioner. He is the officer. The DC had not directly come. He had sent his competent authorized officer, my lord, to depose. DW1, my lord, was cross-questioned by the central government. And he had made a clear statement that no payment has been made to any power of attorney holder, and payments are made by bank transaction to respective landowners. There is thus no legal or factual ground to question the power of attorney. The power of attorney in terms of the attorney is acting only in a fiduciary capacity and not just for his benefit. He is also one of the landowner, in that respect he has represented the other landowners in a joint effort to secure fair compensation for its individual. Now, the Allahabad High Court and other aspect I will touch, my lord, later on. But then the objection from the written statement, what I was trying to point out, is that firstly, their objection was that you had to come with a registered power of attorney in terms of section 32 and 33. But then that seems to be a wrong understanding of the law, my lord. 32 and 33 does not require the attorney to be registered. But then if you present the document for registration as a power of attorney holder, then your attorney itself should be registered. That is what 32 and 33 says. And otherwise, 18F, my lord, clearly covers my case that since it is not mentioned in section 17, it is not required to be registered. Then, my lord, I will come to the next objection, the objection that has been broken up in different parts. I read from para 10, my lord. This is a question that they put.
What's the page number?
Page number 288, my lord, 288.
Yes.
The most important comma, a bare perusal of power of attorney reveals the same is not genuine document having legal validity. It is submitted that as per provisions of land manual dated 6/9/2022, notified for acquisition of land in Arunachal Pradesh, a deed of acceptance of compensation was prepared by the DC at the time of disbursement of the compensation, which has signatures of ex landowners with their respective photographs. It is observed from the power of attorney submitted by the petitioner that signatures of landowner at serial number so and so and so and so and so do not match with the signatures of the owners appended to the deed of acceptance of compensation. Then name of landowner at serial 70 do not match. Owners at 12, 15, 75, 81 put thumb impression on the deed of acceptance of whereas signatures are appended on the POA. There are two signatures in the deed of acceptance in respect of owner so and so. Whereas there is only one signature in the POE in respect of this. So they point out certain specific, my lord, what they say is, my lord, illegality, or I would rather call it maybe a irregularity. They point this out, my lord.
Para 9 also, my learned friend has not read. He has a scraped back. Please, Lordship, ask my learned friend to read first.
Yes. No, please, I'll come to that. Because I was addressing because that issue in a separate IA, my lord. There is a separate IA also filed by me on this aspect, my lord. That one of the attorney holders, my lord, had actually, one of the persons who was named in the original, my lord, land acquisition process, he had died before the power of attorney came to be executed, my lord. His name still figures in the power of attorney. And to explain that, my lord, this aspect, my lord, lordship has seen that para 9 does not say anything specific about that a particular person had died, because this record, as far as this documents as to a death of a particular person, was with the deputy commissioner, and neither in their written statement, neither in our written statement, my lord, sorry, in the written statement of the Ministry of Defense, this aspect had come into light. We had filed a IA and earlier an affidavit also. This thing was first brought to light, my lord, in this appeal. In appeal, my lord, lordship would see that there are two documents filed. In fact, I was somewhere else, but then since para 9 has been referred to, my lord, I would like to, my lord, address that also. If your lordship takes up this volume, my lord, of index of channel. Hello. Firstly, I will come to, my lord, page 399. P99, my lord, is the deed of acceptance, which say that from this we have compared the signatures in the power of attorney and we found some discrepancies. Page 399. Now, one important aspect of page 399 again, my lord, is that This document, my lord, was filed both by the Deputy Commissioner and also by the Ministry of Defense. Now, it had been alleged, my lord, at this stage, because this was not a pleading earlier, that the power of attorney holder had fabricated this document and had put a date of 1st November in that particular deed, my lord. Lordship probably recollects that that issue was pointed out. Now, my lord, this was never my exhibit. It is a document filed by the respondents. So therefore, my lord, I had also put in one more IA, because if this aspect has to be gone in as to who had put the date and which is correct, my lord, the original of the same would be required. Only photocopies were produced, my lord, and the NCR also is having photocopies, my lord, of these documents. The original as to this date of acceptance, my lord, as to who had signed it, what is the date, what is the date of the issuance of the stamp, my lord, would be required to be looked into before we come to any conclusion as to whether this particular document was manufactured by me as alleged, or it was an error on part of the DC, because it's from DC's record that we have got this. DC had given this record, he has filed it as an exhibit, my lord. And I had put a cross question on the DC on that particular issue also, that you have filed this particular document, what is the date mentioned? He says that it's one. So I'll come back, my lord, to the aspect of that, my lord. The aspect of that, my lord, we had filed an affidavit. We had stated, my lord, that your lordship takes up that affidavit, or my IA, my lord, in fact, in this regard. We have shown, my lord, as to how this had happened, my lord. It would be IA 141 of 2025 probably. Lordship has got it. I'll lead your lordship to the document straight away. Lordship comes to page 33. Page 33 and 34, my lord. These are also filed in the appeal, my lord, by them. However, these documents are not before the trial court. So to put it in a proper forum, my lord, application number 41, rule 27B was required to be filed, my lord, to bring this on record. But in any way, since these are on record on affidavit, we are also stating now, my lord, the death certificate is of 10/6/2023 in respect of Tozobam. Now, page 34 thereafter, my lord, the wife, she applies for a succession certificate. She gets the succession certificate on 21st September 2023 from the additional district judge. This is before disbursement of the compensation, my lord. Your lordship could see that her signature is attested thereafter by at the bottom, my lord, by the additional district judge. Now, Tozobam's name, my lord, in the original notifications of land acquisition, Tozobam's name, my lord, was there at serial number 53. At page 35, lordship would see, Tozobam is at serial 53.
Yes.
Now, when this Tozobam died, my lord, at least before the collector, my lord, there was no misrepresentation. The lady herself, if your lordship looks at page 36, Annex 4. The lady herself, my lord, had appeared before the collector. I'm only giving extracts of this document because the main documents are otherwise available. For easy reference, I'm giving extracts, my lord. Serial 53, as you could see, the lady's photo is there. The name is Tojobam. But then, there's a type copy also thereafter, my lord, probably. But then, anyway, I'm pointing to the original. Now, she had not, because lordship would see that the succession certificate, the same photo is there and the same signature is there. She is Bomebam. Bomebam had signed this and signed this also, my lord. So it's not that somebody impersonated Tojobam and took his share of compensation. But then, yes, my lord, a genuine mistake crept in. Because in the power of attorney, my lord, that's serial 53, because that was prepared on the basis of the section 11 notification, which had names and addresses of every person. Against the name, my lord, if your lordship comes at page 38, against the name of Tojobam, the sign is of Bomebam, the same sign as in the succession certificate and in the document in which she had received compensation. So she had not impersonated or put the signature, my lord, as Tojobam. She had put her signature in a genuine manner, her own signature, because as a successor, my lord, she is entitled to the properties of whatever her husband would have been entitled to. The only thing that happened, my lord, is in the description of parties. Instead of Bomebam, my lord, legal hire of Tojobam, that skipped, my lord, at the drafting because, my lord, in the section 11 notification, my lord, his names were there in this manner. So, my lord, it was, my lord, copy pasted in this manner, and therefore this error had crept in, my lord.
I'm sorry to interrupt, my lords. Here, how come in the power of attorney the name can come? My lord, there the name is there because of the reason that the land was recorded in Tojobam. But once after, so the signature was there as a successor before the collector. But in power of attorney, it was not Tojobam. It was she who was executing, if at all she was actually executing. It's not a question of any, my lord, error, corrupting or typing error, or that what my learned friend has said so, my lord. That's why there is clear-cut allegation of forgery and fraud.
Then, my lord, I would also point out, like, my lord, how this typing errors, my lord, perpetuate, my lord. Now they know that Tojobam is there. But in Indian memo of appeal, they again make Tojobam a party.
Yes, in memo of appeal also the same thing has been done.
53, my lord, they have typed Tojobam. Now, therefore, Bomebam is saying that if you were saying that my husband's signature was impersonated, or I had impersonated, or somebody else had impersonated me and put in a sign, I at least have a right of hearing, my lord. I have to be added as a party. Because what is there is a misdescription of party and not what according to us is a fatal flaw. There is only a misdescription of party. And as I had pointed out, therefore, my lord, in the power of attorneys, sorry, in the Contract Act, my lord, these acts can be ratified, my lord, retrospectively. That aspect is there. Of course, it's a critical issue, my lord, but then this is what my subject to, but learned AZ would also enlighten the court about this aspect, my lord. In my humble understanding, my lord, this is how this had crept in. It's not a fact that where, my lord, somebody had impersonated somebody and signed as somebody and come as somebody. Now, if we want to say that this particular sign is fraud, is it not necessary for the person whose signature it is or who says that it is my signature to be heard? Will at least the audio alterum rule not, my lord, permit that? Of course, on merits, any decision can come. On merits, my lord, things can be rejected also, but at least a right of hearing has to come. So therefore, he has filed an application under Order 1 Rule 10(2), which says that if there is any misdescription of a party, the court at any point of time can correct it. Of course, subject to the substantial rights that might flow from it is a different thing. But then at least the addition and correction of that name, and because the same thing, my lord, today, my lord, in the memo of appeal also a dead person is named. Even they have not corrected it, my lord. How can there be an appeal against the dead person, my lord? Since they know, or everybody knows now, that says that. And then since this fact was not specifically brought out, my lord, at the stage, my lord, of where this, my lord, matter was argued before a trial court, it escaped notice of everybody, man. The counsel from that side, the deputy commissioner from us, and the court also was not obligated to look into that aspect. So therefore, my lord, the other IA, my lord, has to be also, my lord, considered. And thirdly, my lord, as I had said, the deed of acceptance, there is a variation of dates. The deputy commissioner has filed one copy in which a different date is there. The DO has filed one copy which is a different date is there. The examination of these two documents before coming to any conclusion, my lord, would be required. Since only photocopies are there, my lord, in the LCR, my lord. So therefore, I had prayed that this document should be placed before the appellate court, my lord, for its inspection so that a conclusive view can be taken, my lord, in this aspect. Then, what I was reading, my lord, I will coming back to the point of, my lord, what is stated in the written statement.
Yes.
They say there are discrepancies in, my lord, the
We had requested
signatures.
also that
There are
investigation.
discrepancies in the signature, and many irregularities they point out, or illegalities, whatever they point out, my lord. Now, what had happened thereafter, my lord, is that evidence can. The evidence, my lord, has not been paper book, my lord, but then I will invite your lordship to have a look there.
Then not part of the record or?
It is part of the record, no, but then it's not filed with the memo of appeal. It is with the LCR separately.
Okay.
Why I will be reading, my lord, DW2. DW2 is the defense estate officer who is the one who filed this written statement. Because we understand that they try to set up a case in pleadings. I wanted to file a paper book, but then since this hearing is suddenly started, my lord, like I also could not get time to prepare.
Is it available with you now?
I have a copy, my lord. I have a copy, but then lordship has to like get it from the LCR. I
Yes,
have,
I have handed over a copy of the all evidence that day in course of hearing, my lords. I handed over a copy of the evidence. Because there is only one DW and three DWs, my lord. Entire was given.
Mr. Pathak, you were referring to DW?
TW2.
Yes.
And just before that, my lord, Lordship is well aware of this provision.
Yes.
That as per order 6 rule 4, my lord, plea of fraud can be taken also in a civil matter. I admit to that.
Order?
Order 6, my lord, rule 4. Particulars to be given where necessary in all cases where parties or pleading relies on any misrepresentation, fraud, breach of trust, willful default, or undue influence, and in all such other cases in which particulars may be necessary beyond such as are exemplified in the forms aforesaid, particulars with dates and so would be stated in pleadings. So fraud is something, therefore, which has to be pleaded categorically, my lord. What I find, my lord, in the WS, my lord, though they suspect, they say that we suspect that this is mismatching, whether it is genuine or not, we suspect that. Though that is there, my lord, what I therefore say that to allege it as an irregularity, my lord, a specific plea of fraud was not taken. They had only pointed out that these are discrepancies that we find. Now, that was therefore required to be once pleading is that, my lordship knows that pleadings are nothing in a civil trial. What is vital is that what is coming in evidence, my lord. Now, the basic rule, my lord, of evidence is that the party who alleges it has to prove the fact. So if I allege fraud, I have to prove it. It's not that I allege fraud on somebody and the other party has to therefore disprove that there is no fraud. This again relates to, my lord, what is there in the Indian Evidence Act as far as power of attorney is concerned. As far as power of attorney is concerned, there is a presumption. So there has to be a rebuttal. That rebuttal has to come in evidence, my lord, not in pleadings. Because it's a civil trial ultimately. So therefore, my lord, the examination in chief of DW2 is vital. He is the one who filed this written statement earlier. But then in the copy that I get, my lord, of his evidence, there is no whisper, my lord, about the power of attorney or any aspect about the same, casting any doubt or anything, my lord, in this regard. I would therefore invite your lordship to have a very quick look. I, Sri Akash Kohli, aged about 30 years, so. I am respondent number 5 in the connected BASA reference case, so. Land measuring 537 acres was acquired by Government of India Ministry of Defence for so by paying total compensation of so. The value of the land is determined under section 26(3). Letter dated demand is the exhibit 1. The land has been acquired by the Deputy Commissioner by following provisions of Right to Fair Compensation Act 2013. Landowners were kept informed about the actions taken by Deputy Commissioner. Acquisition compensation of Iman was assessed by the state government on land rates dated 6/9/2022 for the acquisition of the lands in district in Arunachal on prescribed rates and so. Then he says, upon perusal of the government notification dated 6/9/2022, he speaks about the rate, my lord, that how the classification took place and how it was, my lord, found to be horticultural plain land. And DC had suggested this particular rate, and therefore we had proceeded to pay as per the DC's assessment. That is, of course, the requiring department has to do it because it's the DC who ultimately, it was all, he is the all in all, my lord. Everything comes before him. Requiring department can only have objections as to certain limited issues. Particularly in reference, they can hesitate as far as the rates are concerned because they are the authorities who would be ultimately paying. Then para 6 again, my lord, he says that that assessment sheet was prepared in presence of everybody and they have signed the assessment sheet. Then para 7 says that as per provisions of section 40, 80% was initially deposited and thereafter 20%. Then para 8, he says, my lord, notice under section 21 was published on 19/9/23. Then 21 notice had given opportunity to the parties to object. Then he says that by executing this deed of acceptance, we had foregone our right to seek reference. Then he says, my lord, project affected persons could have, my lord, filed objections earlier also. Then he says that deed of acceptance was, my lord, also accompanied by no change of mind and willingness certificate. Then he says, my lord, this 537 is not prime land and therefore its valuation should be not high. Then again, he says that though it is near National Highway 13, portions of it is, my lord, inside. But then he again confirms that 70% is buildable, which in a hill state, 70% buildable is a huge area, man. Lordship knows the topography here. Then he said that for such and such reasons, we have chosen this particular land. Then he says we are not entitled to interest under section 80. We said that we have paid the total compensation to you. You are not entitled to anything more. Then he says that we have produced certain sale dates, which are of smaller areas, which is, my lord, therefore not to be taken into consideration. Then para 19, he says, my lord, that the collector is competent authority to determine the market value and therefore he hath rightly done so. So on evidence, my lord, where is the rebuttal? No matter how much you argue today, there is no rebuttal in evidence. Only thing that they did is that they put a question on the PW1 who had come, my lord. I have not put any question to them because since you are not stating anything on evidence, why should I be, my lord, asking you questions on that aspect? But then as far as we are concerned, my lord, in our cross-examination, the question was put, my lord. That was probably read also the other day. It is a fact that all beneficiaries are my acquaintances and 10, 12 are my relatives. I have about 50 acres of land. Power of attorney was executed on 9/11/2023 at Likabali. 102 executants of power of attorney came from different places and assembled in the office of the notary. So they tried to say that this particular persons, my lord, they never appeared before the notary. That was the question put. After the person replies that 102 executants were there, of course, 102 would also include that person for whose the wife had come, my lord. But then otherwise, persons were there present before the notary. Now, there's nothing to shake this particular line thereafter. Only thing that he had, my lord, swayed in saying in this particular thing is that about his relatives and acquaintances, my lord. Lordship knows in the smaller clans and tribes, my lord, and they have actually everybody is related to everybody. In Galo, my lord, everybody would be related to everybody in some way or the other. In Nishi, everybody would be related. Even in Missing in Assam and in the smaller tribes in Assam, everybody is somehow related, my lord. So that is not material, whether I am related or not related. So he had slipped at times, like he said that some are my acquaintances, some are my relatives. Then he clarifies also subsequently that some of them are my relatives and otherwise they are my acquaintances. Because he was also having a land there and definitely everybody in the neighborhood would be known to him. Now, in my cross-examination also, as far as signatures are concerned, There's nothing specifically put there that this signature is mismatching with this. This is this, who had signed this? You had not, even a suggestion is not put that you had impersonated this particular person and you had signed this particular document. These are the basic rules of evidence, I know, my lord. That you have to put us, if you want to build a case on evidence, at least you have not given any evidence to the positive. You have not shaken my evidence also. By putting me pinpointed questions, there's no suggestion also that I had impersonated somebody and signed. The actual landowner had not signed and then I had signed it as a power of attorney holder and therefore created a forgery. There's no indication, my lord, anywhere. So this is how the evidence stands, my lord, as far as the power of attorney is concerned. The other witnesses, my lord, they don't say anything about the power of attorney. DW 2 and 3. The 3 and 4, my lord, are 3, 4, 5, I think. The other 3 witnesses from the defense side, my lord, they speak about the suitability of the area and also the fact that the rates should not be that high in that particular area. And the deputy commissioner's deposition, this issue was never raised. He only said that we had followed the government notification of 2022. And as per that government notification, my lord, we have made assessment and made payments. So this is how the evidence stands, my lord. If they can improve the evidence, appellate stays, my lord, how that would be done, my lord, that has to be addressed. But then as of now, what we see, my lord, from the bare reading of the evidence is that only pleading is there, not substantiated by evidence, not substantiated by any cross-examination. And in this regard, lordship, I would just indicate, lordship is otherwise quite conversant with trials, and therefore I would not like to remind lordship about this aspect, but then your lordship would just look into this aspect. For one issue. Hello, 1999 4 SCC 243.
Page number?
1999 4 SCC 243. Some decisions were submitted, my lord, by them, which says that yes, fraud will vitiate everything. There's no quarrel. In fact, your lordship also had said that there's no quarrel on that proposition. That fraud will vitiate everything. But then you have to establish the fraud. The pleading of fraud without any evidence. Was it my burden, my lord, therefore, to prove that I am not fraudulent once I am being alleged to have committed a fraud? Was it my burden, my lord? I'm reading para 23, my lord. All the above three premises adverted to by the High Court are unsupportable. The clear pleading of the plaintiff is that he possesses such property as per so and so. Burden of proof cannot be cast on the plaintiff to prove that transaction was consistent with the appellant's tenor. Exhibit so and so sale deed contain recital of sale and consideration of the transferor. Why should be a further burden of proof to substantiate the recitals in the documents are true be put? So this is in again context of 91 and 92 I read, which has become now 94. That all I am required as far as my document is concerned is to produce the original before the court. And my burden as far as existence of that document is discharged. Now, lordship would have a look at Anil Rishi versus Gurbakh Singh, 2006 5 SCC 558. This is a case, of course, where the plaintiff had alleged fraud. there can be two types of cases, my lord, where in some cases the plaintiff will allege fraud. In some cases, the defendant can also take a plea of fraud. But then the rule, my lord, is in 101 earlier. The initial burden of proof, para 8, would be on the plaintiff in view of section 101 of the Evidence Act, which reads as under burden of proof.
Which paragraph you?
My lord, para 8. The initial burden of proof would be on the plaintiff in view of section 101, which reads as under. Whoever desires the court to give any judgment as to any legal right or liability dependent on the existence of facts which he must assert, he must prove those facts exist. When a person is bound to prove the existence of any fact, it is said to have been burden of proof lying on that person. In terms of the said provisions, the burden of proof that a fact rests on the party who substantially asserts the affirmative issue and not the party who denies it. The Survey rule may not be universal in its application and there may be exception thereto. The learned trial court and the high court proceeded on the basis that the defendant was in a dominating position and had a fiduciary relationship with the party. The parties in the written statement denied and disputed the said averments. Here the case was, my lord, the plaintiff had alleged fraud and the defendant had denied it. In our case, the contrary has happened. Defendant is alleging fraud. We are denying it. So the burden is on them because I come with a presumption as far as the power of attorney is concerned. Rebuttal has to come from their side through evidence. Then the onus might shift on me to prove some other things. Para 10 is important, my lord. Pleading is not evidence. All they have is pleading, my lord, and some good arguments, my lord. Pleading is not evidence, far less proof. Issues are raised on the basis of pleadings. The defendant's appellants having not admitted or acknowledged the fiduciary relationship of the party, indisputably the relationship of the party would be an issue itself. The suit would fail if both parties do not adduce any evidence in view of section 102. Thus, ordinarily the burden of proof would be on the party who asserts the affirmative on the issue and it rests after evidence is gone into upon the party against whom at the time the question arises, judgment would be given if no further evidence were to be adduced from other side. So now they could have done so many other things, my lord. Like they could have said that if they want to say that the genuine landowner had not signed, they could have called the landowner, my lord, to say that whether you have signed or not. Initial burden they have to discharge. They doubt also the notary as of now, my lord. I have seen from the argument.
It was done, my lord.
Could,
in the written statement itself, it was done, and the court was requested that your lordship has just now seen that inquiry is required in the matter, because this is a matter of special knowledge to them only about the.
Then the notary has also not been examined, my lord. So where is the, my lord, the rebuttal? Can only a pleading be a rebuttal, my lord? And if that had not come, can it at this appellate stage, my lord, it be permitted, my lord? There's no application for, my lord, deducing additional evidence also till now from their side. They have filed an application under order 41 rule 27. This is regarding some further notifications issued by the government regarding multiplication factor. This multiplication factor issue, my lord, is a different thing, because these notifications can otherwise also be taken into cognizance as these are government notifications. So for that, my lord, order 41 rule 27 need not be pressed into operation. But then they have not brought those two records relating to the death of the person through a proper application till now. It is still argued, and we are arguing because like we have also filed an application saying that yes, it is a fact that this has happened. But then therefore the court therefore has to now see that whether it had happened maliciously or bona fide, whether it is a curable defect or it's an incurable defect. This is what the court has to see. Then, my lord, as far as attestation is also concerned, I had referred to, my lord, this provision. 2007-12 SCC 190. This is where, from my lord, I was saying that some documents are to be, my lord, attested, because it was said that the power of attorney did not have any witness, my lord. Whether that would render it, my lord, invalid. Para 5, I'm reading, my lord. The trial court dismissed the suit against the plaintiff appellant, filed a first appeal in the
No, this
Court of
is in
Supreme.
respect of section 100.
No, no,
This is
my
not
lord.
Second appeal.
No, no, my lord, what I am reading, because the court finally dismissed it on the ground that, yes, in second appeal, you cannot raise this issue. But then what was the finding of the appellate court which has been
No,
affirmed,
no,
my lord?
this is not second appeal.
In the SLP, my lord, in the SLP, the court said that at the stage of second appeal, High Court ought not to have gone into these aspects. But then what was the aspect that was already decided?
No, no, no. Our case is not appeal of a second appeal.
It's not second appeal. It's
Then-
not second appeal. No, no, what I'm not talking about that, my lord. I'm talking about para 5, my lord, which gives a important, my lord, quote from the first appellate court judgment, which stands affirm, my lord. It appears from the evidence of the plaintiff's witness that Lakshmi Rai and Soya are the same person. Once the plaintiff proves his case to witness, the burden shifts to the defendant, so and so, so and so. The law does not require attestation of a sale deed as a compulsory one. In fact, in the Transfer of Property Act, attestation of a sale deed is also not necessary. Witnesses are not necessary. Party executing it is sufficient. When law does not require compulsory attestation of a document, such unattested document may be proved as per provisions of Section 68 of the Evidence Act. And Section 68 of Evidence Act has no application for the said date. 68 says, my lord, that if it is witnessed, a particular document is required to be witnessed, then, and sign of that witness is there. And if it is required under law to be witnessed, then one of those witnesses have to be called to the court to prove the document. So our case is not a compulsorily registrable, my lord, document. And since it was not required to be registered or also witnessed as per provisions of a law, calling of a witness or absence of a witness in this regard is not material. What is material is that till now, my lord, the landowners, unless they themselves come and say that we are revoking this power of attorney or this power of attorney is fraud, how can on the basis of some mismatch of signature only power of attorney can be declared to be fraud? And that too in absence of any evidence before the reference court in this regard. This may be lacunas in the trial that had happened. But then these lacunas, my lord, can it be cured in the appellate stage now is one question. And the second thing, therefore, I, at the very inception, my lord, I had pointed out is that the reference court does it have jurisdiction to go into these issues? Because its jurisdiction is bound and created by law, and within those four corners only, he has to decide. And that law is settled, my lord. Whether these extraneous things and other things can be gone into, how deep, and if so, how deep can it be, my lord, exercised? Had it been a regular civil court, my lord, no issues. It has all powers. Everything can be argued, urged. But then here the jurisdiction is limited, my lord. So it creates a difficult position, my lord. What Justice Borua's judgment I was reading, my lord, he had given a passing comment thereafter that in such cases, maybe for the party agreed 226 is a remedy. Because there is statute otherwise does not give you the remedy of doing anything in this regard. He makes a remark only, my lord, it is not a finding on law as such. But then yes, because I also had pointed out, even the reference court also had said that if agencies are to be terminated and declared fraud, to prove fraud, is it not necessary that each and every person should also come and be presented individually, my lord? Without hearing them, can it be, my lord, decided that you have given, your signature was impersonated by somebody else? Unless and until that person was called to the witness box, they could have done it. to prove their case of fraud, my lord, they could have called one or two witnesses and done the same. But then it seemed, my lord, from the evidence of DW2, at the stage of evidence, though they had set up this particular plea in the written statement, at the state of evidence, this plea was abandoned, my lord. No whisper in the evidence of any of the witnesses from the Ministry of Defense about the act of power of attorney being fraudulent. And the other aspect, my lord, the reference court has dealt with by saying that, yes, they pointed out there are some mismatches here and there. They said that it might happen, but then how do the court at that point of time go into that issue?
Reference court has not dealt with any of the issues except registration. All those facts have not been dealt.
No,
Anywhere.
therefore I was submitting. Can the reference court, my lord, go into these issues also? Is its jurisdiction wide enough to go into these issues? It may be ours, but then is it the right forum to, my lord, urge these particular issues? And if not, what would be the right forum? The court will have a view, or the respondents can take a call of their own, my lord, on that particular issue. So more or less, my lord, as far as the power of attorney is concerned, I might have missed a few things because like 2 or 3 times, my lord, I had to divert to specifically reply, my lord. The other aspect, my lord, that was argued, my lord, was about protest. But then if your lordship desires to continue today, or I have to address, my lord, some other time, my lord.
How much time it will take?
It would take time, my lord. It is also because those 2 issues, my lord, were vociferously argued on 2 days, my lord, consuming almost 2 hours, my lord. I have in fact tried to summarize things in a very hasty manner. Some of the pages I have not in fact taken your lordship to, because records lordship of course would have a look later on. The other aspect, my lord, is also a vital aspect. They say that the other count on which we assail your reference is that you made no protest. So therefore, what is protest? What is the evidence of protest? What is the law relating to protest? How it has been dealt with? And what actually transpired in evidence, my lord? That thing has to be pointed out, my lord.
Tomorrow we can try, but tomorrow we have division bench also.
I understand. In fact,
matters are there.
and the learned other judge, my lord, also telling that he is not inclined to fix matters tomorrow because DB because this will be the last week of the DB. So matters have to be part matters at least have to be finished.
Yes.
I understand that.
How much time you will take?
Another 2 hours, my lord.
Another 2 hours.
On these 2 issues only. On these 2 issues only.
Tomorrow, 3 o'clock, my lords, if not inconvenient to my lords.
Tomorrow at 3 o'clock.
Or if it can be at 2 o'clock, no difficulty. But if your lordship have any difficulty, then if it can be.
We cannot say at 2 o'clock because some hearing matters are there. It may continue in the second half also.
Lordships. So if lordship may, we can take chance.
Pardon?
3 o'clock, my lord, if not inconvenient to my lords.
3 o'clock we can try.
Lordships.
Tomorrow.
Later half, my lord, I have some arbitrations. I'll try to I have some arbitration with Justice Sharma in the later half, my lord. I'll try to tomorrow later half, my lord. I'll try to adjust. Maybe I'll have a call. We'll try, my lord, because
3 o'clock we'll try.
We'll try, my lord. We'll see.
3 o'clock.
Try to be brief.
My lord, but then at least the facts I have to present, my lord.
You may also file your written argument also.
My lord. But then the other aspect, my lord, I am also trying to highlight is that since in the reference case, my lord, this kind of preliminary issues cannot actually be there. So the core issue of actually what had happened and what we are entitled to, my lord. If we don't argue on that aspect, my lord, I don't know what will happen. We also have to try to address that also, at least in brevity. But then the second point, because of the authority, your lordship had also noted, probably it has been said time and again that there was no protest and like therefore there could not have been reference. And in fact, the forgery allegation or the fraud element comes from there, saying that landowners were not protesting. They had no protest. So how come this man suddenly has come with a power of attorney? He has come only to make gains for himself by an act of fraud. So these two issues are intricately connected, and I think therefore learned AG had also argued both of these two issues together. The second aspect, my lord, I will try, my lord, definitely. We are always ready to assist the
Okay,
court, my
tomorrow
lord.
we'll try to finish.
We will try to assist the court,
Okay.
my lord, as far as
Ah,
possible.
okay.
With regard to
Mr.
the IA application, my lord, can our IA application?
Yes, as per that provision, we will allow you 1 month time.
Lordship, grateful.
Okay, okay.
Great.
My
My
lord.
lord, 1 month from the date of reopening of the Supreme Court, my lords.
Pardon?
Because my lord, 1 month from the date of reopening of Supreme Court, if lordship can grant.
Oh, Supreme Court is functioning today. Learned AG had matters today, my lord. Urgent
Yes,
matters
yes.
have been taken up. Urgent matters are taken up, my
Bench.
lord.
Subject to your lordship's, my lord.
Okay, heard Mr. SD Sanjay, learned counsel for the appellant, assisted by Mr. Y. Dollar, learned senior counsel for the appellant, and Mr. B. Pathak for the respondent. Heard in part, place the matter tomorrow at 3 p.m.
Grateful.
You try to give me this.
The aspect of my
actually,
eyes, I will give a summary also, my lord. I'll try to.
On the other day, Mr. Sanjay has given some part of evidence, but it is only cross-examination of two witnesses.
My lord, my lord. I will try to maybe flag it in the. I'll flag it in the LCR, my lord.
Okay, okay,
I'll flag it in the LCR.
okay.
Lordship, the order will be, so far order on my extension petition, my lords, that will come, my lord. Or tomorrow.
Pardon?
My lord, the order on my application, my lord, IA for extension of time.
No, today we will pass the order.
Lordships, grateful.
We will dispose of the same.
My lord, as far as my IAs are concerned, my lord, I had
That
also
I will
indicated that
respond
these are
tomorrow on my learned
intricately
friend,
connected to these two
tomorrow.
issues only, not something else, my lord.
Yes, I will respond.
We'll place.
Tomorrow we will consider your.
Oh, my lord.
You got a copy to them also.
Yes, I have.
You have received.
Grateful.
Any other members?
My lord, if I may, my lord, item number 16 and 17 may be listed for the 10th, my lord. On the last date also, matter could not be reached. Senior advocates, Sir Amit Kumar is leading us in this matter. My lord, the issue involved is my lord, the issue involved is very small in this, my lord, implement, but my lord, it can be listed on the 10th, item 16 and 17.
16 and 17.
My lord, item 16 and 17, on the 10th, my lord. 10th of June, my lord.
That's spread for by Mr. What is your name?
N. Khera, my lord.
N. Khera, learned counsel for the petitioner.
My lord.
Applicant stroke petitioner. List the matter on 10th of June.
10th of June, my lord.
Okay, all right.
My lord.
May I, lordship? Item number 15, your lordship.
15.
Similar appeal, your lordship.
Well, in the same case,
cause
Deputy Commissioner and the state had also filed separate appeals, my lord.
Yes.
In the same case, same reference against the same award.
Okay.
So what I had initially submitted in this matters is that
You are also in that matter.
yes, we are the respondents there, and it's the same reference case, my lord.
Okay.
The Deputy Commissioner and state has filed independent appeals, my lord.
Okay.
What I had submitted is that section 74, my lord, is giving a right of appeal. It's a statutory appeal. It is only to the requiring body and the landowners. So other persons cannot file appeal, and all they can do is that they can argue their case as respondents in the appeal of the union, my lord. They are still not prejudiced because they can still argue, my lord, their case as respondents in the union's case by supporting the union's case. But on separate independent appeals would not be maintainable.
But how it was admitted then?
It was not admitted, my
Yet to be admitted.
It's yet to be admitted.
No, if it is not permissible, then why should we admit?
No, my lord, here, my lord, whether it's.
Okay, we'll hear.
That issue is also there.
All right. So today it will not be possible.
Yes.
So tomorrow also it may
This
not be
matters, my
possible.
lord, your honor, my lord, on last occasion, that item of 15, your honor
Malad is directed for segregation, but otherwise, Malad, these matters have to be heard together only. It arises from the same award, judgment of the authority.
No, first we will see your locus, whether you can file such an appeal or not. So,
And difficulty, Malad, here, Malad, is that that piecemeal, Malad, manner it is being heard, Malad, that the maintainability and the merit also is so difficult for us also, Malad, in the appeal of the union also.
no, if it is not maintainable, there is no question of hearing you on merit.
Malad,
No,
we're
they may
talking about
still argue their case as respondents in the union's appeal.
otherwise, I'm
They are a
appealing
party
for
there.
respondent of one
They're
zero
appeal
five in
there.
the appeal filed by the union.
What he is probably indicating, I am also suddenly finding it difficult because normally we hear appeal in a composite manner. So frame preliminary issues in appeal, my lord,
Okay,
and
list the,
argue at that on that point, my lord.
list the matter tomorrow. Item 15, along with this LA appeal number 3 of 2024.
3 and
We'll see.
Yes, Malad, appeal will list.
You will see.
Item number 10.
Okay.
How like that?
Okay. None appears for the government.
My name?
No, he is present.
He was here.
Luang?
I don't know where he was waiting the whole day.
Pardon?
He was waiting the whole time, but just now he went out. I don't know where he is.
Oh,
It's or Lordship, at least my interim may be considered at least, and
pardon?
at least my interim prayer may be considered at least. My,
Interim.
Yes. It is just for running of my mela for a few days, Your Lordship. That is the only prayer. No party will be prejudiced by my whole system is suffering, Your Lordship. The same prayer I have been making from the day one.
Heard, Mr. Your good name?
Ketaja.
Ketaja, learned counsel for the petitioner. And Mr. N. Luang, learned additional senior government advocate for the state respondents. Whether he has filed any affidavit?
Yes, that I have received. Even in the affidavit is nothing is written in the affidavit also. They have not given any reason why the therefore you must kindly consider at least interim prayer kind at least. After it is just a matter of 20 days or 30 days.
Yes, Mr. Luang, you file your affidavit.
Yes.
So what is your stand?
For a status, actually, it was not exactly license. Permission was given only for this thing, one, starting from.
May not be licensed, but you have permitted him.
Yes.
By order dated 10th of April 2025. But
Actually, what happened is that Mela was in full swing. In the meantime, there was a video conferencing by this thing, Minister Hope to cancel.
But before passing the impugned order, whether any opportunity of being heard was given to the petitioner?
No, Your Worship.
Actually, it was this operated in all over the state.
Maybe. You tell me, is it was it not necessary for him to hear the petitioner before cancelling the earlier order, permission order?
Our affidavit says, but they were given for 1 month. But they have still been running till, I mean, like 29th of last month. So 1 month is almost complete.
That part
No,
is,
whether that aspect is mentioned in your order?
No,
That
that is,
the 1 month is already over, and therefore the permission order stands cancelled.
of course, the thing was not there.
Hmm?
But about this, I mean, they had continued till 29th of last month. So 1 month is permit for this thing, 1 month.
Okay, pardon is, Mr. Taza, learned counsel for the petitioner. Submits that the petitioner was granted permission by the Deputy Commissioner East Siang District Pasighat by order dated 10th of April 2025 to organize a mini mela at Daily Market Pasighat from 10th April to 10th of May 2025. 10th of May 2025. So the period is already expired.
no,
Yes.
now they said that my mela is run, but it is not running. Because after this order, I approached the authorities to continue, to allow me to continue functioning the mela. Okay, writing in application.
Whether after this 10th of May you have been granted any permission?
No, permission was never granted.
No. Then we cannot grant you interim relief.
After
Actually, I mean,
you receive-
permission order also, this condition is given also.
you receive kindly,
We'll fix the matter for admission hearing.
then tomorrow you receive kindly. For tomorrow.
No, tomorrow.
It's very
Tomorrow
urgent.
may
Your
not
Lordship.
be possible.
At least then your Lordship, day after tomorrow, Friday.
Day after tomorrow we can fetch.
Yes.
Because
It is submitted at the bar that pleadings have already been completed. And the matter may be listed for admission hearing. Accordingly, it is provided that rest shall list the matter for admission hearing on 6th Friday.
Six.
Friday.
But